That'd be great. All right. We have
We're live.
Commissioner Platt as our IT guru for the moment here. All right, welcome one and all to the September 13th, 2023 meeting of Albany County Planning and Zoning Commission. Commissioner David emailed me earlier saying that she's got this snarled up between flights between London and Denver and canceled flights, so she will not be joining us unless she figures some way to Zoom. So this is what we're doing. Yeah. All right, so let's do a quick roll call. Commissioner Hanning here. Commissioner Platt here. Commissioner Cornick here. And David is absent, as I just explained. Hopefully here I am as well. Okay, we have an agenda that was distributed last week. It's pretty long, but I think some of them may go quickly. There's certainly a lot of interesting stuff there. Would anybody like to amend the agenda? They're in content or order. Hearing seeing none, how about a motion to approve the agenda as distributed?
I'm going to approve the agenda as distributed.
For a second. Seconded. Further discussion? All in favor, say aye.
Aye.
Done deal. Next item up is the minutes from our previous meeting. I had a couple of things. Anybody else? Anybody want to comment on those? Corrections, thoughts, questions?
I just had little typos.
Well, let's go ahead and remit. Mr. Williams, you ready for odds and ends? Okay. Mr. Corner, go ahead.
Okay, page 3. It's right about the middle of the page. It says, David Gertz says that the county has not adopted,
Yeah.
Page 4, 1A. Says GIS that instead of and. Throughout the middle of that paragraph, it says GIS and don't follow property lines. K, that sentence just didn't make sense to me also on page 4. It may be best to adopt Stantec proposed cap with the understanding that we can satisfy the surveyability, we can update things. Maybe we just need some punctuation in there.
Possible.
Page 5S. We should say that we request the APOZ boundary be adjusted. If this second to last one.
Yeah.
Okay. And then page 6A. Oh, just commission should be possessive. And D. I just thought the wording was unclear there on D. Right now, the zoning resolution only talks about setting back the wastewater, but Stantec's recommendation is to enlarge that, setting back anything from a vulnerable feature.
I'll look.
Okay. Page 8. Q. Septics are a type of development. Oh, he would split that off.
Yeah.
Septics are a type of development. Yeah, these are really little things, but number 10, Commissioner for Cornick thinks it's not possessive.
Good.
9, 10. 10 consider purview. Bunch of little stuff.
I know it's good to read with that, Karen. I think it speaks the care with which we move to have these in the record as clean as we can make them. Others?
Right here.
Go ahead.
These are all on page 4. Item B or subparagraph B reads Chairman Platt does not accept what the survey said. I don't think we talked about any surveys. I believe what I said was I rejected the assertion that the 75 protected shale line could not be surveyed to an accuracy greater than plus or minus 200 feet. Or is that effect?
So the suggestion would be that staff will go back and just verify what was said.
And that'd be fine. Subparagraph H. Second sentence doesn't make any sense. And what WWC is that cannot be done with the 75-foot line. I just don't understand the sentence.
Yeah, I'll look into it.
It's just missing, you're missing some words.
Just using sad.
And then finally, subparagraph I, meets should be spelled METES. That's all.
Sam?
I don't have anything. I appreciated the lengthy write-up that staff had to do to capture a lengthy discussion.
I see, I had caught a couple of these on page 4 under D. Again, later if you're gonna check the recording. Did Commissioner Ben David say huge error? That caught my attention. I don't remember what she said. But if you remember, that's what she said, then that's what she said. But
I don't remember. I can look into it though.
but you could give that a quick check. And then another just kind of a small matter, say under A, the 75-foot line, I think we should be putting 75-foot line in quotes or calling it what Stantec called it, which is the protective tank and shale thickness line. So we tend to refer to that in an offhand way as the 75-foot line, in which case I think it would be best if it were quotes as a concept rather than a numerically meaningful name. And then just a comment, Mr. Williams asked me to send him the text of my motion, which I did to make sure that it was captured correctly. And Mr. Ayers has advised us anything that we can provide in writing, that's a solid way to make sure that he doesn't have to listen to our garbled verbiage. Sometimes that's inevitable, but if there's something that you want, we just write. You're certainly always welcome to submit that in writing. The specific that caught my attention there, which we'll talk about later, was that we did in that motion that on the APOZ request that any interested party be able to request a boundary change. So we'll come back to that, but that's a good example of just we said it in a specific way, and minutes should reflect that, and I do. So thank you for that. Other thoughts, comments on the minutes? Hearing none, motion to accept as amended.
So moved, Mr. Chair.
Second,
I second.
further discussion, motion, all in favor, aye.
Aye.
Opposed, same sign, motion carries. Disclosures, conflicts of interest, Ms. Hanning, Mr. Platt,
None.
Mr. Crum. He has none. Okay, we'll move us into the first public application, which is a rerun on one that we picked around last meeting. So could we have a full staff report?
Yeah, so this was on the last meeting. There was some language that was wrong. It's all been corrected. So now we should be good to go. Nothing in the application has changed, nothing really in the staff report other than the changes that needed to be made was changed, so.
Good questions for staff? Comments on the staff report? I had one, and it's kind of been my pet peeve, but I keep banging on it. The findings, and I would, like I said, looking at Mr. Ayers, it continues to strike me that when our regulations say the county shall find A, B, C, D, E, that it would be appropriate somewhere in the staff report to say we find A, B, C, D, E as a declarative sentence. As it is, we've we adopted a template where the findings are a recitation of what the applicant has said. And then there's what strikes me as a somewhat oblique adoption of all of those at the end, saying we accept the applicant's responses as findings. Mr. Ayers, could you comment on that? Are you happy with the way we're doing this, or do you think it could be improved? And let me specifically pose the scenario. We're used to thinking in terms of, oh, if we fail to approve this, someone's going to object and we might get sued and we'll have to justify what we're doing. But the opposite of that is also true. But I'm speculating that we may come to the point where someone who disagrees with our decision will say, why did you approve this? Why did you, on what grounds did you find that it had no economic impact? On what grounds did you find that it met these standards? And then we might end up feeling a bit short if that were to come up. So comments?
Sure. So the way it's structured is that it does list the actual findings required. And then I suppose as the basis for those findings, it lists the applicant's response. I think at this stage, when it's coming to you from the planning department, that's, I mean, what other basis is there other than what the applicant has provided?
Well, for example, the staff might review it and ask themselves, do they find the applicant's response plausible? Or is it, oh, I know that applicant and they would never lie. I mean, we would expect that the applicant is going to answer those findings in a manner favorable to their application. So what I would think we could expect as the county finding that is some review of that. And I guess the way I read it is exactly as you just expressed it. The applicant said this was fine, and we accept that with no further analysis or contemplation. That strikes me as rather thin.
Well, that's, I mean, that is the function of this body, is to, decide as a matter of the reviewing agency and a policy recommending body, whether or not that is sufficient.
Okay, well then let me direct the question back to staff. Staff report is recommending to us that we accept the applicant's responses as sufficient justification for the findings. So basically, staff is recommending us to recommend on the board that the applicant, having said so, is sufficient support for the finding. Am I saying that correctly? And is that you gentlemen's position?
Yeah, Mr. Chair, in the analysis, which we do adopt as part of the findings, it says that we've accepted that in the analysis from staff. So we've already said that in the staff report. And then when you make the motion, you accept that and everything else that it says that we accept.
Right, I'm just reaching back into that. If you were challenged, on what basis did you, staff, accept the applicant's representation that there would be no economic impact or there would be no traffic impact? Is there more to it than that the applicant said so? Do you guys look at the road and think about, would there be a traffic impact or not? I mean, are you guys bringing anything to the finding beyond? It said so.
If we've looked at it and we agree with what the applicant says, then no, we wouldn't bring anything else to it. If there is a deficiency or something that we feel should be discussed, we would point that out in the staff report and you would see that. But in this case, we felt like there was, they've addressed what we would like them to address. And therefore we accept what they've addressed. And in the regulations, that's what it says. It basically is like that it is the applicant's responsibility to address those impacts and to show us that they've done that. Once we review it and we say, yeah, they've done that, there's really nothing else that we need to bring forward.
No, but it's more than that. The regulation isn't that they addressed it, it's that they satisfied it. Again, I don't think I'm shaving this too close. And the statements we get in staff report is, yes, they addressed it. they said everything's fine. That counts as having addressed it. That isn't the same as a finding, an affirmative finding on the part of the county that these impacts were acceptable. That's what I'm fishing for, is some justification for the county finding 1, 2, 3, 4, 5, 6, 7 beyond the applicant said so. Like you gentlemen reaching into your own background and saying, we think the applicant's response is reasonable. I'd like to hear you say that rather than this is what the applicant said, full stop.
Okay. I mean, if you'd like to amend our staff reports, that's fine, but at this point, they're still our staff reports. We're bringing them to you. If you have issues with them, by all means, amend them. When we look at an application, we feel like it's met the criteria, we're gonna bring it forward with the recommendation to approve. I mean, that's what we've done in this situation.
So Chair, I'm just drawing on my experience sitting on city planning commission. They would put under like applicant response, and then they under that, they put a paragraph that was like city response. And sometimes all the city response was, we agree with the applicant. Or if there's a discrepancy, then they might point out a discrepancy or something to take note of. But it was just a applicant, city. I don't know if that's what you're looking for here, and if that would be an undue burden, or if it's just a short, like.
Yeah, that's a good point. We did do that at one point. But then it was, I don't know what the discussion was or why, but it was basically that we shouldn't do that anymore, so we have not. So, and I don't know if that came from you or from discussions with the county attorney's office, but that was something that we did at one point have in our staff reports.
I would like to see that again. I'm fishing for an affirmative statement from the county. We find the economic impacts are acceptable.
Right. I mean, and we're, as staff, we're doing our best to do what you guys want to do, but it seems like the rules are always changing, and it's not just you guys, but we're getting other information from other people. And so like, we're not pleasing everybody, obviously. So I don't know. We will continue to do our best, and we can try to appease what you're wanting us to do, but it's hard to do that when we don't really understand. And yeah, because we've changed our staff reports probably 2 or 3 times in the last couple of years now. And beforehand, it was the same staff report for years. So and not that it shouldn't have changed. I mean, obviously, we all want it to be better. We all want it to be more clear. But you know, to us, it's not been clear on many fronts, not just this level.
What Commissioner Henning has suggested is precisely what I'm looking for. And again, I maybe I find you find a different way of saying it, but an affirmative statement, we, the county, or we, the staff, find. And maybe that's just one more sentence added to each one. Does that sound like a useful addition to the staff report, or am I just chasing shadows here?
It seems like it's there implicitly and you're asking for it to be explicit.
I think it's there explicitly.
Who's that explicitly? Okay, well, I'm beating that, and I don't have any problem with this application. It's just that I would like to see something more affirmative voting. So, very good. Let the record reflect. All right, I will move on. Staff can take those thoughts. All right, do we have any other comments on this application? We had a public hearing on it. We don't need to repeat that. Is that correct, Mr. Ayers?
Correct.
Okay, so we can simply proceed to or is there further public comment on this? That's not clear.
Mr. Chairman, do we first need to take this off the table, or?
Oh, all right, let's say a motion take it off the table. That'd be appropriate from a rules point of view.
In that case, Mr. Chairman, I move that we take this application off the table.
I'll second that.
Okay, further discussion of that motion, all in favor say aye.
Aye.
All right, we now have the application for CU 01-23 up for recommended action by the commission. What's your pleasure?
Mr. Chairman, I recommend the Board of County Commissioners approve the following conditional use application CU-01-23, adopting and incorporating the staff analysis, findings of fact, and conclusions of law as each are stated in this staff report.
Is there a second?
I'll second that.
Is there further discussion of that motion? Hearing none, all in favor say aye.
Aye.
Oh, sorry, let's do a roll call vote on that. It's official action. Ms. Annie,
Aye.
Mr. Platt,
Aye.
Mr. Cornick,
Aye.
Mr. David absent, Hinckley, aye. The vote is unanimous and the application goes forward to the Board of Commissioners. Thank you. Okay, second item up is the Logan zoning district amendment, ZBA 0323. Lead a public hearing on these, Mr. Ayers. While he's looking, let's go ahead with our staff report. And dormant services.
It's nice to know where to secure it. So
There you go.
I know you said that outside also.
Open the door.
Just slipped in before 5 o'clock.
All right, we ready?
Yes.
All right, so this is for, the applicant is the estate of William Jarvis Logan. It's located just south of Pumpkin Vine Road. The request is to change zoning from rural residential to ag. The current zoning is rural residential. Access is off of White Mine Road. And the applicant is requesting a zoning district amendment from rural residential to ag. There were some reviews. Assessor's Office, Chelsea Matthews had no concern. Karen Bowman, Senior GIS Analyst, had no concerns. Jake Schneider, County Engineer, had no concerns. Rob Fisher, Superintendent of Road and Bridge, has no concerns at this point. But we'll have more questions later as to traffic volume and number of lots accessing Pumpkin Vine. Snow removal on Pumpkin Vine is limited. Tracy Fletcher, County Treasurer, had no concerns, and Laramie Rivers Conservation District, Holly Dyer, had no concerns, but offered comments as they pertain to the LRCD mission of conserving natural resources and serving local landowners. Her full comments can be seen in the review section. The applicable sections of the Albany County zoning resolution is chapter 3, section 5. Pursuant to chapter 3, section 5D of the Albany County zoning resolution, the applicant has provided the required notice by posted sign, publication, and certified mail. The comprehensive plan, this is in priority growth area 4, where locations tend to be more remote. Staff analysis, the applicant has addressed the potential impacts the zoning district amendment may cause and has provided a complete application. Planning department believes that the proposed zoning district amendment generally follows the suggestions of the Albany County comprehensive plan. These properties are currently zoned as rural residential, and as change to ag is compatible with existing land use of surrounding properties. Findings of fact, the findings necessary for approval and applicant responses referenced in this report are adopted as findings reflecting that the applicant has adequately addressed the specified impacts and the same are incorporated herein. Conclusions of law, the applicant is proceeding in accordance with and is in compliance with the requirements of the Albany County zoning resolution. Staff recommendation is to approve the Logan zoning district amendment application, ZDA 0323, adopting and incorporating the staff analysis, findings of fact, and conclusions of law as each are stated in the staff report.
Thank you. Questions for Mr. Wilms?
Thank you, Mr. Chair. Mr. Lomas. Why would Rob Fisher be concerned about traffic volume when you would think that it would be decreasing going from
Yeah, I'm not sure. It's a big parcel, so maybe he thinks that they're gonna do like a large tract subdivision or something. That's not the plan. So I'm not sure what the thought was behind that.
Do you know when it was zoned, probably from ag to rural residential?
I'm guessing 1997, it said it was some sort of residential, and then 2015, when the zoning went and did its thing, that we know they followed the assessors from 1997, so I'm guessing that's when it happened.
So there's been no planning, no subdivision.
No.
Phase ones or anything. like
No.
that. Thank you.
Others? Yeah, mine was that same one, the words being reassigned, used to be ag, had caught my attention as well, so there's no story there. It's
Nothing that I know of. As far as I know, they've always used it as ag, so I'm not entirely sure.
and we do understand why they want this, more philosophical level, just curious. No, fair enough. Back to Mr. Ayers, the question I ask is, do we need to kind of formally call this a public hearing? If so, we certainly can, and we should just go ahead and do that anyway.
It's been advertised and all that. It should be a public hearing.
Okay, let's just proceed on that basis. So just for the record and for those who might be in attendance, either here or online, the procedure that we would normally go through, we are going through is a report from staff, which we just heard. Then we will invite the applicant to comment if they have any. Then we will explicitly invite public comments, and that will constitute the public hearing portion of our treatment of this application. If you want to make a comment, you'll need to step forward, state your name and address, try to confine yourself to 3 minutes, and then a general admonition that we have an opportunity for broad scale comments, not on this particular application at the end of the meeting. Okay, then proceeding down that order of events, is the applicant here? And would you like to add anything to our discussion?
It's pretty much like that.
What is that? Okay. No problem here. Would anybody like to specifically address a question to the applicant? All right, we can proceed. Oh, I'm sorry, was there? Yeah, go for it and step up here, give us your name and tell us what's on your mind.
Nancy Bath, we're adjoining landowners, and I support this decision fully for them to have this revert back to agricultural land. That's what they seem to be using it for, and I think it's appropriate for the area.
Okay, thank you. Thank you for your support. Hearing no other public wants to participate, anybody online? I'll take a motion to close the public hearing.
So moved, Mr. Chair.
Second, from a second. Mr. Platt. Discussion of that motion, all in favor, say aye.
Aye.
Opposed, same sign. Okay, close the public hearing and move on to discussion amongst the commission. What's your pleasure to dispose of this application? Comments, thoughts?
Seems straightforward to me.
That's it.
No problem.
I would just add that I applaud this commitment to maintaining agricultural space in the county, and I think that's a good thing for us to be doing. So I have no other comments. Hearing, seeing none, go right ahead.
Mr. Chair, I recommend the Board of County Commissioners approve the Logan zoning district amendment application ZDA 03 adopting and incorporating the staff analysis, findings of fact, and conclusions of law as each are stated in this spec.
Second.
Second that.
And moved and seconded, that we proceed to recommend approval of these zoning change to the Board of County Commissioners. What say the commissioners? Ms. Henning?
Aye.
Mr. Platt? Aye. Mr. Corner?
Aye.
Mr. Hinckley? Aye. It's unanimous. Thank you very much. And you don't need to stick with us for the rest of our meeting. We appreciate you taking the time to come, both of you. I appreciate what you're doing out there for Albany County. Okay. That completes our applications. Yes. Moving us to current planning projects. First of which is subdivision resolution amendment regarding access. Who's delivering the staff report?
All right, so we brought to you some language on the July 5th meeting, is that right? That's not the right date.
Previous meeting, whatever.
The July meeting, and it was put out for public comment to be potentially approved tonight. I believe you also asked that we keep chugging along with potential changes to that. And so we've brought to you some changes to that for potential changing, I guess. Yeah, so I guess it's in your hands now.
But just explain to us the changes you made.
Sure, so there's a red line version. It's quite a bit. We added some variance language. We changed the lot number from 20 to 30. We changed some of the language and then added the variance possibility and added like the standards to what you would need to accomplish to be able to get a variance.
Thank you. Questions for staff?
So I'm just trying to apply this to the situation of the paddocks. So the dead end, referring to the dead end would take care of like City Ranch Road, not going any place in the other direction.
Correct.
Okay. When you say 30, if somebody comes in with a subdivision proposal for 30, but they're gonna do it in additions, would just having the 30 be the trigger? Or would you have to wait for the 30th lot to be platted before it would trigger this kind of road?
I mean, I guess from our thought, it's the 30 at the preliminary plat stage. But maybe that's not addressed the way that you want it to be in how we came up with the writing. So maybe I don't know. You would like it to be more clear?
I just want to make sure that there isn't a loophole there that would again allow somebody to put off the second access. So I mean, I guess it's how you apply it. If you apply it that if you're coming in with a preliminary plat with 30 and that makes you do that second access, then I'm all for it.
I believe that's what we were going for.
So, yeah, Mr. Chair, Commissioner Henning, so, they'll come in with a preliminary plat and that's when we're requiring all this information. And so it'll have to be shown on the preliminary plat. So if they come in after that with, whatever, maybe the access issue doesn't get taken care of until all of the phases are done, but it'll still meet that criteria because that's when it goes over through 30, right? So in theory, I guess, unless there's if there's 100 lots, maybe it'd be more complicated, but even then we would push to have that taken care of once it hits that 30.
But in this case, the preliminary plat would have to show where the second road was. They have to have the easements all in shape, and it wouldn't be some we'll figure it out later kind of situations.
Correct, yes.
Okay.
And if they ever wanted to change that and do something different, they'd have to do an amended plat, but we would then make sure that they continue to have that access with an amended plat.
Did you run these draft regs by the county fire district to see if it met their needs?
This new iteration, no, they have not seen that.
But if we all agree this should go out to public comment again, you'll make sure it runs by those.
Yeah, absolutely.
Okay, thanks. That's all I have.
Mr. Clark? I'm fine with this as is, and I think we should contemplate scheduling a public hearing for our next meeting. Well, the next bill meeting, I don't know if that'll be November or not. Based on the amount of time we have. At any rate, I'm fine with it as it's presented.
Okay, other questions?
No, I think it's well done.
So, why the change from 20 to 30?
Well, that's what International Fire Code says. And then we don't get a whole lot of these. And we're trying not to make it an all the time thing. But you know, if there's subdivisions that are adjacently going in using the same roads, that it would apply to them as well. So I guess that's our thoughts on it.
Okay, I just wondered where the number 30 came from. That's a reasonable answer. Let's pursue Ms. Hanning's question just a bit. Maybe there is no answer. If I were to do serial subdivisions, there's nothing that prevents that. Is there? Am I required to do multiple filings? What's the difference between the multiple filings on a single subdivision and simply doing a new subdivision, calling it ABCD?
Well, I mean, potentially rules would change. If you do one preliminary plat, you're kind of under that one preliminary plat. Whereas if something changes and you have one subdivision and then the rules change and then you want to do another subdivision, you have to follow those new ones, I guess.
If I wanted to develop a very large area, it seems to me that a developer have the option of platting it at the preliminary stage all at once, or simply doing it as 5 subdivisions. Is there any policing, any
I
way?
mean, you could do that if you were to do like, say, a small subdivision first and then want to do another small subdivision on that same kind of parent parcel. You would have to go through all the major subdivision stuff anyways, because of that like consecutive subdivision rule.
Okay, maybe that's the rule I'm fishing around for.
Yeah, the benefit would be to do the preliminary plat all at once, is like you do all the studies all at once and then you're done. You don't have to pay for it every time, like kind of what Joe was saying.
Right.
But with the way the regulations are written, it doesn't matter if they do one big preliminary, then obviously, yeah, this is all gonna kick in. But if they're doing it, okay, 10 here, 10 here, well, now we're doing 10 here, then it kicks in, that access rule. So however they meet the 30, because if they're all using the same accesses, once you hit that 30, whether it's multiple subdivisions with multiple preliminary plats, it will kick in that they'll have to have that second access.
Okay, it doesn't read that way to me.
It does, yeah.
Does it?
Well, if they're adjacent, so, I mean, could you leave a little strip in between them and not call them adjacent? I don't know.
People have done worse.
Yeah, I'm not looking if there's some tricky way around it.
Yeah, I mean, it looks like you've addressed that, the idea of serial subdivisions with the adjacent.
We thought we had, so I mean,
Yeah,
if
that was
it's not reading that way, then.
No, that was my concern. And it looks like that is covered. All right, that's all I had. Were there any public comments on this? At this point, just to make it available to you. And hearing none, the idea that these changes are large enough that they would count as substantive, that we would want to go back out for a renewed public hearing.
Yes.
And George is nodding his head. That sounds like that is the staff recommendation. And our options were to what in terms of timing?
Yeah, it says November 8th here.
And our next meeting is
October.
But to do the 45 days.
the 30 days.
Yeah, it'd be 30 days for us.
30 days.
But even so, we're past that.
Okay,
So it'd be November.
okay, I understand. Thank you. What's your pleasure, commissioners?
Mr. Chair, I move to direct staff to publish the recent amendments to the Albany County Planning Subdivision Resolution for public comment and set a public hearing for the November 8th, 2023 regular meeting.
A second. Seconded to move forward with public comment period and a public hearing. Further discussion? Ms. Hanning, how do you vote?
First, I just want to thank the staff for really upping this and addressing the issues. I think you did a really great job, so I'm voting for.
Okay, thank you. Mr. Platt? Aye. Mr. Cornick?
Aye.
Hinckley, aye. And that passes, and staff can proceed to advertise appropriately. Thank you. Okay, APOZ boundary amendments. Well, let's start with staff report. Mr. Birch.
Yeah, so Mr. Chairman, Commissioners. So at our last meeting, we discussed the boundaries, obviously, and then I think we did did we review the text that we need to? I don't know, we've got both.
Mostly we talked about boundaries.
Mostly boundaries, okay. And so we put together a hybrid boundary. Joe put together some maps, quite a few different maps, kind of showing the different boundaries. So we've put those together. We put together a map that could be approved tonight. That is the hybrid map. It would basically replace what we currently have in our map book for our zoning. So we have all that. And I just, if you've read my staff report, I just reiterated kind of my reasoning that I like to follow the cap or the kappa boundary that's found in the cap. I mean, I guess they're both found in the cap, sort of, but the one that's recommended in the new adopted cap. And I won't necessarily read through all of these things. I'll just kind of summarize them. You know, one of the things that I don't think I brought up before is the protective Satanka shell thickness line isn't meant to be a static line, at least from the language in the plan. It talks about it being updated as new information comes in. So that would be something that can be moving as we had more information. Which you know, if you have that as your line, then okay, now we're going to have to be amending the map at the same time instead of just it's kind of amending in the plan, and we're keeping track of that. I already brought up, I guess, what WWC engineering said about that. I won't rehash that. And then it's my understanding that city staff is going to use the Stantec, or not the Stantec, but the adopted cap boundary, which follows property lines. Ultimately, for staff, it would be so much easier, and that doesn't mean it's the best way, I guess, but to administer the line, if we could say, yes, you're in, or no, you're not. Now, that being said, I am sympathetic to property owners where they have a corner that is just barely crossed by that Satanka protective line, or protective Satanka shell line. So anyways, I still recommend that line, but we've given you all the information that you've asked for and desired. And then also Matt and I, mostly I think Mr. or Chairman Hinckley has been involved as well with the text amendment. We also provided you that, which we've spent a lot of time on working on in the last month or so, for your consideration. And what this does is, this is kind of the written, this is what it looks like, this is where it came from, this is how to amend it. That's what that is. And so we provide that as well. And that's really all I have to say. I mean, I know there's some more discussion to be had. I also did want to note that we do have some individuals in the public today that have came and are prepared. They're ones that will be affected by whatever we do at the boundary. So just to put you on notice that they're here. If you give, I mean, I'm sure you'll give them a chance to to give their spill as well. So just wanted to notify you of that. So.
And remind me, I made a note to myself.
Okay.
I go really kind of, don't be shy about waving around. Okay. I have a lot of comments on the staff report and some specific amendments to offer to the text, but let's kind of see what others have in mind. How do you want to proceed? Should we just dive in, or some preliminary comments from any of the rest of you? Jen, you want to just
Well, I guess,
start in a discussion, or did you have some specific?
I think just general discussion right now, because I'm still wavering about what the line should be. I was a proponent for going with the property lines last time, but I felt like Mr. Ayers was advising against that as being less defensible. And I assume you guys have been talking about what went into the staff report, or are they running amok and not getting their attorneys' input on the line?
Or let's hold that thought for a second. I would like to go through a little exercise I did with Mr. Gertz to address your first point, if that's acceptable to the commission. And that's just a look at the lines on the map. Was that a useful thing to do? Were there some just other preliminary thoughts?
Well, just a preliminary thought from me is that I favor going with a hybrid line at this point.
And that was what we came out with as we want to see what it looks like at our last meeting. Mr. Koenig, do you have anything to start us off with?
When do we find out what the city is gonna do? Because I mean, there's some reason to look for consistency.
Yeah, I spoke with Mr. Moody, the chair of that commission myself, but I understand they're talking to Derek Key, the city planning director. So go ahead.
Yeah, I don't have much to report. They did discuss it briefly at their meeting, but they were kind of discussing what we were doing. So like, I'm going to discuss what they're doing, but it sounds like they will have it, I believe, on their next meeting this month to discuss. Is that?
Yeah,
Chris tell you that?
Yeah, what I understood is their discussion Monday, just this last Monday, the city planning met, their procedures are quite different than ours, and they go through 3 readings at city council. So he came away from their discussion on Monday, not particularly disturbed that we might not do things exactly the same, and kind of a you go first, no, you go first, no, you go first. So my understanding from Mr. Moody was that they were not uncomfortable with us proceeding with the understanding that they will have a comment. And then I would add to that I've had a specific conversation with both Mr. Moody and Mr. Teeny, saying we recognize that there's no legal reason that the lines have to be drawn similar, like identical criteria. There's a general spirit of we want to be cooperative, and we have a joint cap now. But that, at least in my representation of the county's interest, is that we definitely want the city to be comfortable that the county is being adequately protective of the city's water quality interests. And that's the bottom line. And how we go about that in terms of our texts and our maps is up to us, as long as we meet, in my mind, that threshold that they're satisfied that we are looking after their constituents, which are about a 90% overlap with our constituents. So we are continuing that thread. The conversation I had with Mr. Teeny specifically was he wasn't sure how that endorsement might manifest, whether it's simply a discussion or whether it's a resolution saying we like what the county's doing. I spoke briefly with Councilor Doherty. She favored something of a more formal nature where the city council would say, yes, we like what the county's doing, but that's all in flux. Does that adequately address your thought?
Yeah.
Okay. All right, then, since we got the cue from Ms. Hanning, and I asked David to be prepared with the GIS, could we bring up those maps? I sat down with Mr. Gertz and went through this exercise, and I'll say I was originally a proponent of the property lines for all those reasons that they're definite, they're administratable, And it isn't just for the convenience of the planning, but for the convenience of developers or anything else where they stand. I think that's a solid argument. The question then becomes, what else is going on at the same time? So what Mr. Gertsch and I did is we sat down and just measured at various points the difference between the Satanka protected thickness line and the proposed border that follows property lines. To get a feel for it, those properties just south of town, I think, showed that, where are we here?
This is the very south.
Very south, yeah.
Do you wanna, where do you want me to start?
Okay, let's pan up slightly. Okay, so, well, all right, there's a big rectangular spot there, kind of in mid-screen now. Measure us off some distances, say between the black line and the green line at the top of that guy. So here's a case where everything to the left of the black line would be subject to the table of prohibited uses, for example. Okay, that's 1,000 feet. Now just pan south. As we were doing this, there were many that were in the 1,200 foot range right now. There's one where it clips the corner, for example. There's a just to the left. That property, just go left, go west, just a slot. Okay, there would be a classic example where you clip the corner and it brings in the whole, what's that, probably a 40, and your buffer there is then nearly 1,500 feet. Further south, there's a spot where you kind of ran right down the east property line. Yeah, just coming into view here. Look at those little properties there, where you're just clipping those eastern corners, and your buffer then is like 1,000 feet. If there's any place else you wanted to look, well, let's go north. Show us that icicle, as I've called it, up there on Rogers Canyon Road. And if there's anything else you guys wanted to look at, I'm just kind of giving you the quick tour here. Yeah, keep going. So the icicle. Sorry, no, a little further. There it is. Okay, so here's a case where the green line is the property line following boundary. If you measure from the left side of the icicle or dog tooth over to the black line, that's gonna be quite a ways there. So a quarter of a mile. One more thing to look at. Let's go in town. Something that shows about this discussion I thought was valuable. Oh. And the point I'm looking for, Mr. Gertsch, is where we've got those little bitty lots like through Laramie Plains. And there the difference is small simply because you've got a granularity in your lot size. And so you can approximate the black line with the stair-step green line. So this goes to whether the issue goes to whether the city and the county may need to do this in exactly the same way. The city really is a different kettle of fish in that they have much smaller lots, so they have available to them this option of a really small displacement. All right, that's what I was looking at and thinking of some of the public comments we've got, and then felt, gosh, you think about what's goes on APOZ table of prohibited uses, probably most conspicuously, potentially some serious septic concerns. And again, just speaking for myself, that seemed like a bit of a reach. Now, I would also point out that with respect to Mr. Gertsch's endorsement of let's do what Stantec recommended, and we adopted the cap as recommended, fair enough. I think it was version 3 of the cap, however, Stantec came to us with a hybrid of sorts where there were certain rules that they said, if you're east of the protective line, this is what happens. If you're east of the boundary, this is what happens. So in Stantec's evolution of Stantec thinking, there became this kind of a north-south strip of indeterminate or highly variable with where certain things applied and certain things didn't. If you'll recall, that came up at one of the meetings of the joint meetings of both planning commissions and EDC, and we suggested, and I think they quickly tumbled to, let's not have two western boundaries. So it isn't quite like Stantec thought this all through and firmly recommended, let us have the property line boundary. That concept originally came to us from Jack Whitman, who did the 2008 update for the city. And they recognized that there were significant errors in where the boundary had been drawn by the delineation committee back in 1998. And the solution that he proposed was to go to property lines. The city adopted that, but it was easy for them because they were adopting something in the county that they didn't have to live with. The county rejected that. That was one of the reasons why the city and the county split in different directions with the cap back in 2008. Okay, so by way of background. Is there anything else anybody would look at on the map? I just felt that was a strong statement to me, at least. All right, as I parsed this out, it looked to me like there are four issues here. The first one is the big one of what boundary do we want to proceed with as between the Setanka protected line, the cap property line boundary, and this thing that we've come to call a hybrid, or some other one entirely. Secondly, we want to decide how that boundary is going to be represented and administered. Our choices there are to leave it in a GIS environment or to make it part of an official printed paper map, and Mr. Ayers has got some thoughts on that. The third thing was who gets to seek a boundary change. The draft regulation has been brought before us, confines that to property owners. And then fourthly, what are the criteria that an applicant would have to bring forward to make those changes? So perhaps, again, anybody have a better plan now, or let's take those in order, or I think we should take them in order. Okay. All right. So setting aside surveying and so forth, do we wish to proceed with which of those boundaries? Thoughts from the commission, please. Mr. Black, you expressed your support for what we're calling the hybrid boundary. Let's go, Carter.
So if I understood the staff report correctly, then we have to do all that very expensive GIS or the surveying in order to use the protected boundary. That appeared to be a reason not to use the hybrid.
No, we don't have to do that. Okay, and I'm thinking that's a different issue. Okay, Mr. Gertz.
Yeah, so, Mr. Chair, that was, I guess, Commissioner Kokornik, that was the opinion of the engineers that we talked to, was that if we're using a line that's not along the property boundaries, that would need to happen. I mean, and that's their opinion. I don't know. I mean, I think there might be other opinions about that as well.
Oh, so that's kind of issue number 2, maybe.
Well, that's what I'm thinking of. So,
Okay.
you know, we're not gonna walk in on the
I mean,
hybrid.
if that were necessary and those resources don't exist, then it's not an option, right?
Okay,
But
if that weren't an issue, which line do we like the best? I
okay,
guess
so
is
that's
my
what we're
question.
talking about right now. Okay.
And then where do you land on that?
I mean, I think there are good reasons to use the hybrid because it is an imposition on people to have to do the site-specific investigation if they only have a little corner of their property in the, that may not have the 75 feet of overlying Setanka shale. So that would be my preference if it's feasible.
Fair enough. Ms. Yanni?
I'm sympathetic to the hybrid line. And I guess mostly because of some of those properties that you were showing the measurements of how much gets pulled in. But I guess my ultimate concern is just what's going to be most legally defensible and administrable. And also, I guess regarding the city county, how we do it, just to be thinking about what happens in the case of annexation in the city. I mean, if the city's doing it one way and we're doing it another way, does that make any kind of mess? I don't know. Maybe it doesn't. But just the question of annexation. And I know I've mentioned this before, but maybe this would be an arbitrary and capricious way to go about aligning things to property boundaries. Would it be feasible to say that if your lot only contains a certain percentage of the not protective amount of Satanka, could you go to the eastern boundary of that property? Would that be another way to take care of some of these lots, or is that like a loosey-goosey arbitrary thing, Mr. Ayers, to say, well, you only have 10% in the cap, so we're gonna let you go over to the eastern side of your property?
Okay, so let's jump to Mr. Ayers here and ask you to also address in the staff memo is described a meeting with surveyors. Where the opinions were offered that to be legally defensible, it had to follow the property lines. To create a legally enforceable line, I'm quoting from the staff memo, could ensure a lengthy defense, a legally defensible boundary. I think what we heard from you, Mr. Ayers, is that one could legally defend the hybrid line. So could you speak to that for us?
Certainly, that is getting directly into the issue 2, however. So would you like me to?
Please.
Okay.
I think that everybody's kind of circling around that one, so let's
Okay.
get in on that.
So in terms of absolute legal certainty, correct. You have to have that survey tied to section lines, quarter lines. Because that is the only way that you will get the same exact line on the ground 100% of the time, with 100 different surveyors stating exact points. However, that is, and that's the standard for like a property dispute with your neighbor. Where exactly does your property begin? Where exactly does mine end? But that is not the case for zoning districts. Based off of my rather extensive research, the standard, kind of as a compilation of various cases throughout the county, is that you create a physical static map at appropriate scale. That map is adopted affirmatively, and then that is the deciding factor. So long as it's at an appropriate scale, then David's office, just as they have been doing for how many years now? 10? Longer than 10 years, has been doing. It's a line on a piece of paper. The line on the piece of paper is static. It doesn't change. What we were informed by the WWC engineering and their surveyor is that when you have a GIS coordinate, it'll get you darn close to exactly where that point is on the ground. But 100 different surveyors staking that exact point 100 different times, there will be variation. It won't be the same exact point every single time. I think it makes sense. Generally, GIS data is not admissible in courts throughout the country as compared to actual survey data. That's obviously what a court would go with. So a static map, it fulfills a standard based off of my research, and it also has the added benefit of just getting rid of that entire issue of GIS versus surveying. And further, GIS data can change rather easily depending on what overlay you're looking at. And you can't definitively prove each time that, well, I suppose you could, but it would require someone with far more computer expertise than me to show that, there hasn't been a single deviation between, what was adopted years ago and what is being displayed in a digital environment now. Whereas with that official zoning map, and I just want to remind everyone that, you know, we have, as part of when we changed from the zone change to the zoning district amendment, we also kind of adopted these official zoning maps, or I guess reinforced them. I think they may have been there previously. But that, you know, I mean, it suggests a physical map, are those official zoning maps, and there are those official zoning maps which you can download off of the planning website. So that is based off of my research, and just weighing everything that has been said. That's my advice.
All right, so it sounds to me like we can parse that into two pieces. One is we are on adequate legal ground to move forward without having a surveyed line.
Certainly.
Am I understanding that correctly? Okay, so we can, now, how we represent this non-surveyed line is another question. Okay, so to the first, are we okay with your questions of what we're hearing from Mr. Harris? So he's basically giving us the go ahead to say, if you like the protected line better, we can make that stick legally. I mean, you never know until you go to court. But that's that's the general sense.
I mean, and also, Mr. Chair, if I may, I mean, this is not, other counties throughout Wyoming have overlay zones where it's not perfect with property boundaries. There's been no case law on it, but this is not a novel concept.
Okay, and let us note that we have had a non-surveyed line for 20-some years now. My discussion with Mr. Gersh, he made the obvious observation that how it would be administered in practice is someone would come into the office, you bring up the GIS, you tell them where they were with respect to the line. So only under the most kind of excruciating microscopic examination would these other issues come up. That isn't to say they won't, but we don't need to protect ourselves against any conceivable microscopic examination. So again, as a tentative step, or we're satisfied that we are not moving into legally perilous territory. Is that fair, my colleagues? Okay, so that.
Yeah, in choosing a hybrid line.
Okay, thank you. All right. Again, tentatively, I guess I'm hearing a consistent response to my first question. How do we represent that boundary and administer it? Now, Mr. Harris is suggesting that it be on paper, but correct me if I'm wrong, I thought with our official zoning maps, we had actually changed the language in our zoning resolution to represent those maps as a graphic representation of the zoning boundaries, with the understanding that if you really wanted to know where a rural residential zoning changed to agricultural zoning, you would go look at the property descriptions. With the understanding those all follow property lines. Am I not remembering that correctly?
Yeah, well, so I mean, the definition for zoning map, the graphical geographic depiction of the zoning district designated for each parcel in the county.
I think I may have been involved in those words, and my point was that physical maps, the maps actually were created from the meets and bounds descriptions from the assessor's office. It didn't used to be maps when we originally had zoning, so we know in terms of the history of zoning in Albany County that originally the zones were map free. Is that correct, Mr. Gersh? Okay, then someone illustrated those long tables of properties with the map. So my point is that the map, under the current phrasing, as I interpret it, is not the final word. The final word is the survey lines for zoning, conventional zoning boundaries.
Potentially.
All right. So then it seems, is is a GIS shape file. It has the advantage of being scalable. If you do the math, a pencil line on a topographic quad, which we're all familiar with, would take about 3 quads to cover the area, 1 to 25,000 scale. A millimeter line is 100 feet wide, give or take. So a pencil, a drawn line on a map has that ambiguity associated with it. Inevitably,
It's actually worse than that.
better scale is worse than that. I know.
Well, I mean, if you were to go to a surveyor and say, we want to survey the APOC, partially they've got boundary lines described legally, how descriptions, and then they just got this line, which isn't described by anything other than just a line on a piece of paper. It's quite unsatisfactory in that respect.
Well, right now it's designed, it is represented as a GIS shape file.
No, I'm saying if we were
If
to
it
go
were to go
to
to
a paper copy,
Right.
we would have three sides that were defined by proper descriptions, and then it's just lines, not defined by anything.
And the
It's a
line,
problem.
yeah, I agree, and I would also then reach back into the development of the protected line. Where that comes from is our consultant's interpretation of the geology as represented by wells, which are located by their GPS coordinates. So the entire concept of the shale protected line is intrinsically founded in GPS and GIS, and it's brought to us as a GPS shapefile of infinitesimally width line, Mr.
Okay, so in any event, when the county commissioners go to approve the district boundary, there will be a map representation of what that boundary is in the staff packet. If there is any question of what, where exactly the boundary is between, I guess, like a digital environment and whatever was adopted as part of that staff packet, the staff packet will control. So maybe paper map is not the correct word. It'll still be based off of those GIS shape files. It will just be a static representation of what that is, which is ultimately control.
And that's fine. As long as we understand it is a representation of the actual line, which is a shapefile.
Right, but, for terms of the regulations, you say it's the map that was adopted by the county commissioners on X date.
All right, the amendment that I was going to propose, maybe if we could get a little bit ahead, but to try to crack that nut was not to have the text say as depicted on the official Albany County zoning map, but rather to say as presented in the GIS shape files dated such and such, maintained and made publicly available by the Albany County Planning Office. Why would that be an unsatisfactory way to commit this to text regulation? And that shapefile is a static. It's a binary file. It's a string of zeros and ones that can be memorialized in precise terms.
Just say skip that middle step and show the map. And show the actual representation, not the raw underlying data.
Well,
And honestly, in that case, you should incorporate that into the text.
that's the amendment I just read.
Now, like the entire shapefile, like as depicted by these coordinates.
So it would not be acceptable in the zoning resolution to refer to a specific shapefile maintained and made publicly available by the.
Well, made publicly available. I mean, what is that? That could change.
It's a file. It's just.
Between, okay, yeah, but
It can't change.
so then include the file with the staff packet.
Certainly in the file, I mean, that's not a problem.
Or just incorporate that file into the regulations.
That's what I'm suggesting, but I guess I'm hearing you want to see it printed out, the file?
Yeah, you need to as part of the staff report.
As it-
Otherwise,
it is.
there's no record of what that file is,
So like a printed legal description, is that what you're saying?
basically.
well, can we legally describe a digital file? You want to see the hex code, the binary? I'm just confused on what this thing would be.
Yeah, well,
Yeah,
we could print
I
out
mean,
the
yeah.
coordinates, that would satisfy what I'm saying.
Otherwise, how do you know what that is? I mean, it's just a file that you've referred to. What file is that? It's whatever David would represent. I'm not trying to call him to question David's integrity whatsoever, but he could say whatever he wants it to.
But by the same analogy, when we're referring to these other boundaries, we're just referring to the legal property descriptions. We're not appending those various property descriptions to the packet.
Those are static though.
Well, you-
Those are
This is static
filed.
also.
No, but those are filed in a public record.
Document. But how does this relate to what you said about GIS data not being admissible in court? And it sounds like we're trying to make it the file be.
Yeah, so I mean, just, generally in courts throughout the country, when you're having those kind of like disputes over property boundaries, just because of the uncertainty of GIS data. Actually, for those of you who followed that corner crossing case in Corbin County, that was a point that the judge made, is based off of like this printout of Onyx. It shows the GIS point, but we don't know exactly where that is.
Well, that's a little bit different. They're referring to what someone's looking at their handheld device, whereas what we're talking about is identified unique points on the surface of the earth which don't move. They can be, if you go out and try to measure them, there will be some amount of error associated with locating that exact position, as there would be with any point out there, whether you're talking about a legal property description or whatever. There's always some amount of error, but those points are unique. They don't move, they don't change.
And could be represented in English text, an Arabic number.
As a coordinate.
As a coordinate.
We can certainly do that.
Okay, we're all learning something here. So is there no legal manifestation of digital files? I guess I'm a little perplexed in this day and age that isn't something that one finds in American jurisprudence.
You give the file. You print it off, what that file is, and you append it to things. I mean, you show the file, you don't just refer to the file. How does a court know what that file is? You just give it its name.
But digital files, unless they're just text, don't lend themselves to appending. That's where I'm getting confused.
Well, I mean,
There are references to.
this would be analogous to a legal property description. If we just, printed out all the coordinates described in this line, that would be the same as having a meets and bounds description of a property boundary. I mean, it'd be analogous, I should say.
And there are 213 of them.
There's roughly 200 or so. And we could certainly print out those coordinates and they would make sense to anyone looking at it.
So does that strike you as meeting the need to have a static printed document? If every point on the shale protective thickness line were given coordinates in standard numbers?
So, I mean, it's gonna open up that uncertainty of where exactly someone's property boundary is, whereas a static representation shows you the property boundary as it existed on whatever this date is, and the line. I mean, so there could still potentially be a fight about, where exactly that is on the property. Whereas that's just settled by the physical representation.
Well, what about the thickness of the line? I guess I'm feeling like there's ambiguity in either case, and it's on the order of 100 feet, 200 feet.
Well, actually, I disagree.
Okay, go ahead.
With a line on a paper map, there's great ambiguity. I mean, there's no way to say where exactly that line is. Whereas with the coordinates, we know exactly where that is. And just hypothetically, if some property owner wanted to subdivide their property that was being crossed by the protected shale thickness line, one way they could go about it, I don't know how a surveyor would do it, one way they could go about doing it would be to identify the monuments describing the property and find the GPS coordinates for those. And then find GPS coordinates for the line as it's crossing the property and compare those two things and find the intercepts. And where the intercepts are, you can then prepare a new legal description and take that home. And that would work. And to address something you said earlier, I don't believe we would need to survey this line for this entirety. It would only need to be surveyed if and when someone went and modified the line. Otherwise, we know where it is. It doesn't have to be physically staked on the ground for us to know where it is. We know where it is because of the file that we have the scan tag.
That we haven't heard from Ms. Carnick and Ms. Panning. What do you have to say about this wide-ranging discussion?
Just taking it in here.
I'm just wondering how county staff implement it when someone comes through their door. If you have all these coordinates, I mean, these guys, for all practical purposes, are going to be looking at the map with the line on it and saying, I think where you're subdividing, this part would be in, this part would be out. I mean, but I think we have to, it's sort of melding together the legal defensibility and the actual practical implementation that staff have to be able to do. Can it be both? Can it be all the coordinates and the line that is in the Casper Aquifer Protection Plan? Well, as amended to be a hybrid. But I mean, all those maps are already depicted in the cap. And we're just talking about taking two of the maps and putting them together essentially to make the hybrid, but they're already printed maps in the cap. So I don't know what the answer is. This is complicated.
Well, the printed maps in the cap, and I quarrel with the intermediate step, they are printed from GIS files. They're printed from lines of infinitesimal width at whatever scale the document producer wanted. So, yeah, and that goes forward. Print them on postcards, print them on a map the size of the wall. The question is, do you need to have a in your hands printed copy of or representation of those points?
Based off of my research, that is the standard.
That is yes.
So,
Okay.
so what we have now is a map. And that when somebody comes in and wants to know if they're in the zone or out of the zone, you look at the map,
No, you look at the GIS, right?
or you look at the GIS. I mean, has the whole, has
Quickly,
this been a
depth on
problem
this,
so
or-
far? I guess we've had a line for a long time.
Yeah, if somebody comes in right now, we pull up the GIS environment and look at the line that's on there and determine where.
And that's been working for a long time, decades.
Yes.
So are we overcomplicating this?
But that being said, we do have an adopted map. Like paper map that goes with that.
Which we could still do both, right? And it has, in practicality, it has been working that way. And it has survived challenges, presumably. Has it? I mean, I don't know if it's.
We've never had a challenge on the location of a line on a specific property.
Because it doesn't follow property lines now, right?
I mean, we've had someone, I mean, we did have that one property where there was, some evidence was being brought forth to say that it shouldn't be where it's at or whatever, but like, no property owner has disputed the line when we've shown them where it was at and said, yeah, do it on this side of the line and not on this side. No one's complained or.
So our hybrid line is moving it, but it's gonna be the same process, right? And that process has been working.
Well, it hasn't been subject to challenge. I mean, I think Mr. Harris brings to us this, okay, if CU are challenged, I think chances that are very small. I think the hybrid line will sell quite comfortably. So the chances of that happening are small, but we shouldn't leave ourselves with unnecessary legal exposure. It is based on
It's not
definable
just pulled
points.
out of the air, it's not arbitrary, just like the line we have now. So
I mean, I would just
why
say
can
that
we not do what we've been doing? Just put the line in a new place.
we have an actual map book, paper printed out in our office. We've got multiple where it's got every I think it's based on township range blocks or whatever. And then it has the aquifer protection overlay zone as well as the neighborhood conservation overlay zone. We have a book in our office, so we can use that, and we do use that sometimes for zoning, so I'll pull it out, but I guess, in my opinion, I mean, can we have a map and use the digital? I don't know. That's what I want. I mean, that's a problem.
I mean, that's exactly what our suggestion would be. We would definitely have a map that people would look at. But if you want to know exactly where the line is, we refer to the shape file, to the actual coordinates. And here's where it comes up. If you want to subdivide your property, you're probably going to subdivide it, you're going to bring in a surveyor, and they're going to use the legal description to describe the property and identify where that subdivision is going to take place and line and all that, and send back a legal description of that proposed subdivision. And that's the way that process works. If you want to subdivide a property that's being crossed by a line shown on paper, there's no legal description for that line. And
Well, but you also have this file, just like.
yeah, no, yeah, as long as we're talking about the file, that's fine, but if you want to rely entirely on a piece of paper, there's a problem.
It seems like we already
Yeah.
have those two things for the line we have now. We're just proposing a different line because we have new data.
So if there were a dispute right now between somebody, if they walk into Mr. Gertz's office and they say which side of the line I'm on, he brings up his GIS and says, you're in. And they didn't like that, they would say, oh, but the paper copy says something different. Is that's how we would see this thing shaping up? And Mr. Ergy would say that paper would rule in that dispute. To the extent anybody could interpret the paper.
So again, I think paper is not the correct, because I mean, it'll be a digital image. I mean, in any event, like with what is actually attached to the packet, which is adopted by the commissioners. It's just the static representation of that line.
So in this dispute, nobody would drag in that paper that was approved by the county commission. They would go to the digital file that created that paper. Is that correct?
They would essentially go to like the PDF of what it is. And that PDF has two components. It has the GIS points and also a depiction of where that is in space. So that's based off of my research. That's the two things I'm showing, or that is required is, the depiction of you have to show the depiction of the line in a physical environment or in a geographic environment.
Okay.
So
I think we're in the same place.
Yeah,
The
I think
depiction
we're-
of the line, but the line.
the depiction of the line, but not the GIS coordinates just by themselves.
Okay,
Right.
but if
So-
someone
Because they
is,
don't mean anything to them.
right, but then here's the depiction of the line, but then if we are in a dispute, somebody says, well, where is it? Really, because your map is too the wrong scale, we would then generate a map at whatever scale we wanted. And we would generate it from the GIS, from the shape file. Or the PDF, I mean.
From the PDF,
Okay.
from the PDF file, which, I mean, a suggestion to David was like, put that like Mylar sized, the actual file.
So
So
you still
that,
have to pick a pen width, but that's just a depiction.
that's the depiction. And yeah, you could still pull that raw or that GIS data out of the file. But for the purposes of text regulation, it's that map. Which is adopted, not the GIS points individually as they exist in whatever shape file. I'm sorry, I'm gonna have it.
PDF is scalable, and that's just a formatting thing. All right, sounds to me like we're in the same place.
Yeah.
But for purposes of description in the regulations, this is my suggestion,
Okay,
that it's based on the delineation, or as depicted in the official Albany County zoning maps. How do we get something in the official Albany County zoning maps? Commissioners have to approve of the map. Not GIS points.
But the GIS points
Are
generate
in
the map,
Yes.
the generated map, so they are there.
So the
But
wording.
it's a matter of what you're calling to.
Okay,
Because then, for purposes of the record, there has to be showing, yes, this was what was adopted by the county commissioners.
so the words being suggested to us are as defined, as depicted in the official Albany County zoning maps, period.
Mhm.
Okay, and then we would all understand that that depiction is generated from a shape file.
Yes.
Okay,
Because it refers back to the Casper Aquifer Protection Area in the cap.
okay,
And the cap is the GIS shapefile.
all right. This maybe was just a big semantic excursion. And ultimately we'll be looking at the text. So then are we satisfied with the text as offered to us in paragraph 5A? I'm seeing nods down the table, Mr. Platt. I was intending to, my language kind of quibbled with that, but I guess I'm satisfied. Well, I'm at 5A under aquifer protection overlay zone established.
Okay,
First, that first paragraph, in the middle of it, the suggested language changes, the APOZ boundary and zone 1, et cetera. You find that.
I'm fine.
Okay.
yeah, I'm fine. I'm just wondering if we should somewhere here reference the file and perhaps append that file coordinate form to make it absolutely clear if there's a dispute over where that line is, what we're referring to.
Well, I think Ms. Hanning has addressed that in her comment that it later on refers to the cap that was approved, which isn't.
To me, makes it sort of implicit that
Yeah.
that's what was the basis for the map and the cap.
Well, we're talking about record, so that's good.
No, I'm qualified.
Well, if y'all are satisfied with that, I'm satisfied with it also.
There's a bit of an understanding there, but all right.
So what was the language change then?
No.
None. Okay, I was like,
What was different here?
okay, just making sure.
Okay, if we're gonna continue my taxonomy, there was also some discontinuity in who gets to seek a boundary change. Where we left it at the previous meeting was anyone. The text that is being brought to us as a draft confined it to the property owners. Mr. Gertz, do you want to explain why you thought that was a better way to go, or where are we on that?
Yeah, Mr. Chair, thought we discussed this. I guess I don't remember that was the consensus of the Planning and Zoning Commission. If that was, then I can make that change, but it is definitely preferable for staff to keep it to the property owner if they want to investigate that line on their property. I think that would be appropriate, but for others outside of their lot, could be anybody outside of the state, anybody. I just think that's not right. I don't know. It just doesn't feel right. I don't know. So,
Yeah, the motion that came out of the meeting last time was any interested party can request an APOZ boundary. To do
there was
so.
a motion on that.
That was my motion and it was passed, and that's
Okay.
I would move forward, but that's not.
And I'm happy to make that change. I just didn't catch that. So,
But let's talk about the philosophy of it, and my response to what you just said is, if anyone discovers an error, a new well gets drilled and there's a fault that no one knew was there, and it turns out that that line is just in the wrong place, I think we would welcome their petitioning us to move the line. I don't understand any association with the owner. What we're looking for is someone who has good reason, and the draft that's been brought to us is quite thorough in saying, here are the things that have to be found to move the line. So, no, I just don't share your discomfort at all with opening that to the adjacent neighbor, somebody from Mars.
Well, it just seems to me that paragraph B above sort of allows for that, right? Because anybody under the Administrative Procedure Act can come forward with an amendment. So like if you were diligently looking at new state engineer well logs and discovered more information that would merit a modification to the cap, then anybody could come in under the Administrative Procedure Act, if I'm recalling correctly, and ask this body to consider an amendment. And so if you're, right now, the door is open to somebody who's concerned about whether the line is accurate to come in and do something without being the property owner.
But that's just as true of the property owner. I mean, if we want to allow boundary changes to be brought forward under just the general, anybody can suggest a change, then let's do that. I'm looking for some symmetry here. What this does is it outlines the explicit findings that are required to make that change. And that shouldn't apply to just the owner, that should apply to these other people as well. So we could go either way, but I think we ought to be consistent that how do we do boundary changes? Are they just brought forward as any amendment could be under by anybody, anywhere, anytime? Or do we want to have specific criteria in which those boundary changes would move forward? I'm just suggesting that everyone should be treated equally in that discussion.
I think we leave it open to anybody. I don't think it's likely as a practical matter to come up often, if at all. But I mean, we might want to make changes. Suggest changes to the line at some point down the road. We would be a property owner.
Good, Gordon? Thought on that?
Yeah, unless staff think of specific problems that could come up that haven't occurred to us.
I mean,
My office tends to be the place where people come to get back at their neighbors. And this to me would open that up again to do that. You know, people want to do things. I mean, there was an instance some years ago where someone wanted to do something on their property. Well, we had it in there that anybody could come in with a report and try to get that line changed, which is what happened. And that just seemed wrong because this individual was going through the process to do something, and then the rules were going to change in the middle of the process, if that would have been approved. Again, which seems wrong to me. I feel like this provision is for individuals on these individual properties, for them to get an out, basically. This is their way to, if they feel like they've been harmed by the line, they have a way to rectify that. Not a way for someone to come in and extend the line and, you know, increase, you know, line on somebody else's property just because they want to or whatever. And that, it happens.
But they couldn't do that without some data, right? To indicate that the line actually needed to be moved.
No, they would have to have data. They'd have to go through
So if
this.
the line did need to be moved.
Why is it, I mean, the process should be going through and changing the Casper Aquifer Protection Plan and look at more than just that site-specific property. I mean, if we're looking at more than one property, then by all means, let's look at that and bring it in and do a change to the cap and make the amendment. I've always been a proponent of that. I think that's the appropriate way to do it. If it's going to be outside folks that are not property owners, this turns into not a way to rectify the situation for the property owner, but also for a way to punish the property owner if somebody wants to. Whether that's true, I mean, that's how I feel. That's how I see it. I just think it's wrong when people come in and try to like dictate. That's what your job's for. That's what the Board of County Commissioners' job's for, is to come in and to make sure it's equally, just some equal regulations are equally applied to everyone in the same way and not pointing out a specific property. That's what gets me, is just looking at a specific property and somebody can come in and just finagle these things and basically change the regulations on them. Somebody else, that doesn't seem right.
Well, I guess, I mean, but the point of the whole thing is to protect the aquifer. So if there's some data that would indicate that the line is not in a place that's protecting the aquifer and some activity is going to happen that's going to endanger it, then we would want to address that. If the data exists, it seems like we could use it. But I mean, I understand you don't want to be the mediator for neighbors' disputes. And
I mean, that's kind of my job sometimes.
the point is to protect the aquifer.
What happens, yeah.
We'll get to Mr. Ayers in a moment here. Mr. Gertz, I'd like to respond. My point on that is, if I wanted to harass my neighbor, I could come in and seek a change in the cap and a change to the line. So I'm policing the harassment potential by setting up a fairly careful procedure. You gotta do this, you gotta do this, you gotta be on a report, you gotta have, you gotta be willing to fund a peer review. I had that same question in my mind, is this a way for a neighbor to just harass the neighbor? And my conclusion was, by having these criteria listed in all these findings, we very strongly discourage a casual, oh, I hate Fred and I want you to change the line on him. And by the same token, if somebody wants to come in and change the line more globally, they too should have to go through these specific criteria. So why?
Then why require it if that's what's gonna be? If they can't even use it, why are we requiring it?
Should we not have specific criteria that we want to find to move the line? Yes, I think the answer is yes, we do.
No, absolutely, we need criteria.
Okay, and that should apply to anyone seeking to move the line, landowner or non-landowner. That sounds fair to me.
Again, I view this as a way for a property owner to change the line if they feel like it's wrong on their property, not for other property owners to change somebody else's line on their property because they don't like it.
But the change is made through this process and this decision-making body. Nobody gives the neighbor the right to go change the line on their neighbor. They would have to go through this whole process. They would have to satisfy this body that they had findings. They would have to satisfy a peer reviewer at their own expense. I don't.
Seems a lot of stress on that property owner if this is happening to their property.
But that would
Somebody
be
comes
just
in
as
too
true
fast
if
in
someone
that way.
came forward and said, I want to move the line through the APA. I just don't see any difference here. We are interested, as Ms. Kilcornick said, in protecting the aquifer, and if somebody brings errors to our attention, those errors should be subjected to a rigorous analysis process, as has been outlined here. Anyway, that's where I'm on. Mr. Ayers, I think you had something you wanted to say on the subject.
Yes, thank you, Mr. Chair. So just completely opening it up to anyone, there will be standing issues. Just at the base level, standing requires you to have, or at least in zoning matters or land use matters, have a more peculiar interest or specific interest than just the general public. So, I think that a lot of reasons, like if you're, drawing water from the aquifer, that will seemingly, confer standing for having the peculiar specific interest to, I guess, change a boundary on someone else's property. However, the same could not be said for someone in Albany who, has really no interest in, unless they're not on Harmony's. They're not on City of Laramie water in Albany, are they? In Albany? Yeah. Right. So, yeah, someone out there that, they have no reliance on the Casper aquifer for their water. Yeah, that would be a big standing issue. And I guess, I think a potential solution to all this might just be that it is property owners and the Planning and Zoning Commission, and people can always petition the Planning and Zoning Commission.
Just feels like a question. The standing thing I don't understand at all. Our regulations create standing, no? We aren't a court. We are saying we will invite petitions from anyone. Are we not free to invite petitions from anyone? The court would say, no, you can't listen to a petition from so-and-so, even though your regulations provided for it.
Standing will still come in. I mean, this is administrative procedure. You don't get rid of that just because it's outside of a court. I mean, what is their interest in having this? I mean, I think it could absolutely get successfully challenged on that.
And the challenge would be, so somebody who lives somewhere where they aren't immediately affected under the provisions of this zoning ordinance comes forward with their proof and their suggested line, and they submit themselves to a peer review. And this body were to agree with them, that decision would be challenged on standing. Is that what you're contemplating?
Yeah, I mean, essentially they didn't have like a sufficient interest to bring in an application in the first place. That is what I'm envisioning.
I guess I don't understand that at all, but what's your sense of my symmetry issue? Should we not have criteria? These are the findings that should be made to move the boundary that would apply to any boundary move. Why are we only applying these very rigorous criteria to an owner seeking to move the boundary rather than to anyone else who's bringing an error to our attention through other procedures? I mean, the way they're set now under APA, it's just as wide open. Anybody can come to us and petition us to change our rules, right? And they are all subject to a standing challenge.
Well, is this a change in rule?
Well, it would be a change in this resolution, amendment to the resolution, and in that the resolution includes the boundary.
Yeah, there's also still that as applied aspect. And yeah, I think that properly that would be the Planning and Zoning Commission that would be bringing that forward.
Then should we recraft this to require ourselves to make these specific findings? What I like about this is it says you have to have geologically legitimate data. You have to be willing to expose that to a peer review before you change the boundary. Those are good criteria for
Okay,
however we got there.
I understand. My apologies. Yeah, I mean, I think that the standing issue, although yes, that is really ruled more on in a court setting or an appeal setting. I mean, there's a strain of logic that I believe would be applied to a situation like this, and other members of my office also believe that. But there is the provision in both 18.520, I don't know the exact number, but it says that people can petition planning and zoning to change a resolution or a comprehensive plan. Well, comprehensive plan, which includes zoning, and also, the APA aspect. So I don't think that it is just completely legally indefensible to allow anyone to open up. But I think that I would be not doing my due diligence if I didn't tell you it could get weird. If you have, a property owner from clear out in the exact western edge of the boundary trying to get someone else's property.
But wouldn't that be just as true if they came to us under those provisions that you provided? My understanding is anyone can come to us for any reason and say, I would like to have you change your
Yeah,
resolution.
Well, that would still be the case for changing the cap, the cap itself, and then making a boundary change based off of that. Do you see, because you could do it that way always. Because the way we have it laid out right now, it says either site specific amendment, or, based off of an updated cap. So that would be how, I guess, those general people, and arguably under the strictest construction of 18.5.2 whatever, that speaks to, the comprehensive plan. So that would be their avenue there. And, since it's essentially land use plan, comprehensive plan. So I guess that, yeah, it would be potentially arbitrary for them to just do it through a site specific boundary amendment when they could accomplish the same thing by going through a petition for a change in the cap and then a change on the regulations based on the cap, since that process is also iterated.
And the they in that statement is the owner as well as anyone else.
Or anyone else specifically.
Why do we grant the owner the special treatment I keep coming back to?
I think the burden of presentation would be lower under the Administrative Procedure Act to come in and make an argument for amending the cap to change the boundary. All you have to do under the Administrative Procedure Act is accompany the petition with relevant data, views, and arguments. I mean, each agency may prescribe by rule the form of the petition and the procedure for its submission. So I guess we as a body could say, well, you gotta bring in everything we're telling the landowner they have to do, or you could require less. So I think it's covered. I mean, if somebody really wanted to come in and change the boundary via the cap, they got it in the Administrative Procedure Act. I mean, to me, that's how I'm not a lawyer interpreting it.
Yeah, no, that's actually a good point.
And just strip all this stuff about the owner has these special subjects.
Well, unless you want to make the path clear to the owner. As David is saying, if you're trying to create an obvious path for remediation, but then you have to have really somebody passionate about aquifer protection who's going to come in and make a petition under the Administrative Procedure Act, as opposed to a neighbor trying to exact revenge or whatever. I mean, so it seems like for people who really want to protect the aquifer, there's a way to come before this body and make a petition. And if you lay out the homeowner, the property owner's route, which is more specific than what you're asking them to prove, then it's an obvious avenue for them to take. So I think we cover all potential parties by leaving it the way it is, the way the wording is right now.
Okay. Other thoughts on that? The amendment that I would have made was just to say any interested party rather than the owner and such. But yes, there are paths available to everyone here. Which is more rigorous and which is less rigorous is subject to interpretation. Others.
And if somebody drills a well and gets some unexpected data, we're interested. Even if they don't go through the whole process, they could just, email it to the chairman, and we're interested, right? We want to know where the actual boundary is. So, and if we get enough of that, maybe we decide the boundary.
You're right.
Right, yeah,
Right.
they hire another Stantec or to do another revision based on all the new wells data that's gonna come up in ensuing years.
Okay. Okay.
I think it's okay the way it is.
All right, before we start offering specific amendments, let's talk about the fourth question I had bears on these specific criteria. We're requiring if we proceed with this draft, the homeowner has to bring a survey of the line. And now it seems to be, we've crossed that bridge in our earlier discussion. So the wording that I was going to propose to get around that would be provided in a form compatible with the existing APOC boundary delineation as determined by the planning director. That would replace Romanet 3 under what the applicant has to provide. So, any thoughts on what appeared to be a discontinuity between this whole business of surveying?
Well, I was going to suggest adding some language to, if you call it subparagraph I.
Yeah, triple I was where we talked about what they had.
No, but I'm talking about I now.
Okay, I'm with you.
What I would suggest is where the last sentence reads, a legal description of the proposed boundary line shall be included with the site plan, continuing with, along with GPS coordinates describing the modified section of the chill thickness line to at least 1 centimeter precision and in the same format as the original Stantec defined or shell thickness line.
Okay, I don't think you addressed my concern that the legal description would be a survey. Or were you thinking of it meaning something different?
No, this would require a legal description and also modification of the Stantec shell line file.
But there is no legal description of the current Stantec shell line file. It doesn't have a legal description as we were discussing earlier,
So
so.
we are requiring, in here, we're requiring, it would require the landowner to provide a legal description
Right.
of the proposed boundary line.
So
So I'm saying, along with the legal description, also coordinates describing the modification.
But the point I'm trying to make is why would you require the legal description? Because you don't have a legal description prior to this, so you're requiring this applicant to do something that we have not done ourselves.
Well, I didn't write this language here, so you're asking the wrong person about why we're requiring a legal description. It sounds like a good idea to me.
Even though we don't require a legal description of ourselves. That's the discontinuity I'm seeing is that earlier we had a discussion, we're not going to survey the protected shield line. It exists as a GIS shapefile. So why not have our applicant bring us a GIS shapefile by way of suggested modification rather than requiring the applicant to go and perform a survey?
I see what you're saying now. I'd be fine with stripping away this and just having GPS coordinates and the modified shapefile.
And my suggestion would be in a manner compatible with the APOC. That would be left somewhat squishy enough, the planning director, whether that was individual coordinates or some other shapefile.
Yeah.
So just strike the sentence on a legal description.
I would strike the legal description and I would modify Romanet 3 as I read earlier. Which would not say based on proposed site-specific policy.
Oh,
I'm
because
sorry.
the modification is based on the site-specific amendment still.
Oh, yeah, okay, I guess I'm not modifying Romanet 3, I'm modifying Romanet 2. I would strike legal description.
Just stepping back from that, again, just thinking about our defined line right now that we have from Stantec. If we're going to modify that line, we want a recording of the new line.
Yes,
So that's what I was trying to address here.
yes, and what I was suggesting is that we be slightly less prescriptive in how that line is described.
Slightly more descriptive. Doing my suggestion, so I'm very good with the way, but we're just.
So let's just so we're clear where we are.
Yeah.
Okay, yeah. My thought was that anything that would fit in with the existing shapefile, whether it was through individual coordinates or not. Okay, so that's good to define that difference. Other thoughts on what we would require of our applicant who wanted to move the line? That's good, Carter. Annie.
I guess for practical purposes, someone is gonna move the line by doing some borings or a well installation. And they're gonna come up with a thickness of Satanka. And they're going to extrapolate between what they're finding in their boring to what other nearby wells have found. And they're going to make a suggested new extrapolation of where the line is. And that would have to be like, that's what Stantec did. And because you're requiring a professional geologist to do it, you'd be like, okay, it makes sense, looks like it makes sense. We'll go with where your new line is on your site plan, and we will amend the cap over time to include these line changes.
Okay, so you would not need a legal description of it. You
Right.
could do it like Stanton did it. And might that be accomplished by simply striking the word legal? The description of the proposed boundary line shall be included with the, maybe that's as simple as that.
Yeah, I think that would work.
Okay, where it sounds to be like we are, please remind me, is that we're happy with the text that's been brought forward. Up through that last little bit, I would lobby it opening up to anyone, but it sounds to me like the consensus of the group is not to.
Or that the pathway exists through the administrative procedures.
And that is in the existing text.
Yeah, in the new text,
Yeah, I mean, the existing
Yeah,
proposal from
yeah.
staff, okay. And if you're happy with that, then I won't run that to a vote. The only amendment then that I've heard would be to strike the word legal at Romanet 2. Oh, all right, long discussion to get, would someone make that motion?
Mr. Chairman, I said that we strike the word legal from subparagraph, it's double I on page 7.
Is that clear to staff what the motion
It's
is?
the last sentence.
Is there a second?
I'll second.
Is there further discussion of that small amendment? All in favor, say aye. Aye. Opposed, same sign. Okay, now, it strikes me that we have something that is right for public comment. And bearing in mind that we can change short of the final decision by the county commissioners. We were soliciting public comment on it. Well, let me open that right now for public comment. I'm sorry, we talked about that earlier. Mr. Harris looks like he has something he wants to share with us before that.
Oh, hello, Eric.
Please
I
do.
think I
Yeah,
followed-
Yeah, sorry, I just wanted to clarify and correct an earlier statement of mine, in which I said that GIS generally isn't as admissible. GIS can very well be admissible in court. It's just, it runs into more problems than, survey descriptions.
Okay.
Just so I don't want to mistake the law
Thank you
in front of a tribunal.
for that clarification. My sense of it is let's move into the 21st century. Legal precedents were developed at earlier times. At some point, we'll catch up.
There's a strong argument for that, certainly.
Okay. All right. Are there any public comments on that subject? It looks like we've worn everybody down. All right. What are our options? Mr. Gertz, remind us. We can put this out for 30 days, schedule public hearing. And that couldn't be at our next meeting because that's not.
Correct. Yeah, the November meeting.
So our choice would be a special meeting or November. Would Commissioner Ivera care to share a thought on pace with us? Would you like to see us move this forward via a special meeting? My sense is it would be a very short and perfunctory one, or wait on the cycles to come around? Any thoughts you'd like to share on that?
I guess I'd like to see things move a little bit quicker and all, but I don't want to put the burden on you guys on having a special meeting just to do that.
How do you feel about it, especially?
I've got no problems with it.
I feel like we should keep things moving. I'd be willing to do that.
I would be. Okay, Renat, what's the calendar say, Mr. Gertz? You publish the comment. 30 days.
October 16th. Ish. That, so if,
Would be the soonest.
yeah, we would have to get something on the paper tomorrow. We'll have to it'd be in Saturday's paper or whatever. But then the 16th or whatever.
Sorry, Mr. Chair, there has not been a motion, correct? Okay, I would,
We're crafting that motion.
yes, so for purposes of crafting that motion, if I could recommend to also direct staff to include with the publication of the amendments, that official county zoning map depiction of the boundary.
Understood.
Thank you.
But we don't, this isn't the day, so.
So is October 18th?
Yes, if
part
that-
of that?
If that week of
The week after our regular meeting?
I was there. Yeah, that is the.
yeah, late in that week.
I will probably be out of town for both of those meetings, so I'll try to zoom in.
Okay, are you back later in the week? It just doesn't include.
More like 20th, yeah.
Yeah, okay, sorry.
Okay.
Yeah.
The week-
I mean,
Yeah, I don't know if Wednesdays,
I have other maps.
Days of the week, that might be yours for me and my work, something that next week, would that accommodate all of us, you think, the week of 22nd?
do they
Now,
have any-
give you guys a little more slack on getting published. Do you have anything going on the week of the 22nd? Include a short meeting?
The 20.
Does it matter when the commissioners meet, as far as being able to deal with it?
They would then meet the following Tuesday.
Because it's
No, they
a
missed that
five.
one, so they could be 2 weeks.
They wouldn't have an extra commission meeting because it's
25th
a,
isn't good for me, but other than that, I think.
But then they could take it up at their first meeting in November, which would be on the 7th. That would move things along.
Okay.
What were you saying, Mr. Gertz?
25th is bad for me, but other than that, I'm good.
24th, that's the Tuesday.
Mr. Chair, what time would that be?
Well, that's.
what are your concerns?
24th is bad for me too.
Sorry.
Okay.
Thursday, the 26th, what's that like?
No, I mean, I don't know where we all are. I'm happy with, again, the time of day doesn't matter either. I don't work an 8 to 5 job. Sandy recently has taken on the yoke of corporate America. Plus you're probably constrained. I don't know.
5 o'clock would be pretty good for me on the 26th. Is that?
That works for me.
Okay.
This is October.
26th.
Okay.
October 26th, and we can change that. I mean, we don't need to notice that special meeting immediately, right?
No, we'll just send it to the paper like the week before, saying
Yeah.
I'm having a
Okay,
meeting.
so there's some flexibility, but tentatively, let's schedule that for October 26th, 5 o'clock. And then you can publish the,
Oh. Yeah, it will be a public hearing, so yeah, we are noticing in the, we would need to know before we publish.
notice
on
it with
Saturday.
this, the 30 days.
Yeah.
Yeah, so
Actually, we wouldn't have to get it in
When
by Saturday.
when that ad shows in the paper, it's 30 days from that.
Okay, so you've got some days to get that put together, but let's go ahead and notice that.
And then we close the public, we give the public 30 days, even though the meeting is a little further out, so that they can look at comments.
Right. I think that's become a standard, has
Is
it
that
not?
the standard now? Okay, that's good.
Say written comments are due by X Public hearing is what?
That's a Thursday, October 26th.
Uh,
So, Mr. Chair, is now the time to make a motion?
Okay, it looks like there's some discussion going on over there. Let's hear the results of that.
How far out are you planning on cutting off? The public comment?
Let's notice 30 days of public comment, whatever that brings you to, and then the special meeting will be thereafter.
Yeah, I mean, I think if we have a couple days, that's enough.
Oh, and that'll
As
give
long as
us,
it's not a couple hours.
Can we get like, I mean, if
well, that'll give us a
the
week.
packet, including all those public comments, get out to you Monday, would that be
Like the
30
23rd?
days from when the notice appears?
Like cut off public notice October 23rd? Yeah,
Well,
that
we'll
would be
cut it off as
that would be
at
at
30
30
days. We'll just plan on that.
That's fine.
Okay.
Yeah,
Yeah,
that's fine.
Paper and then just set some copies.
Okay, so now we are ready for a motion.
Well,
I didn't-
I'll take a stab.
All right, go for
Mr. Chair, I move to direct staff to publish for public comment in a public hearing the aquifer protection overlay zone established portion of the zoning resolution as amended tonight. And to schedule the public comment period to end 30 days from publication of the notice, and for public hearing to be held on October 26th at 5 o'clock. Did you get it all?
Do we need a location?
Nicely done.
it. Is that
Oh,
It's kind of a single.
yeah. Um,
Unless you guys want to be at a restaurant or something.
Including,
Oh, including the maps. Including the
Including,
maps.
Okay, yeah.
Anybody want a second?
I'll
Okay,
second that.
we have a motion and a second. Further discussion. Staff, you had some issues of room availability. Was that what I heard here?
We'll have to check just to make sure.
Okay, find us at home and we'll accept that. There was a second. There was a second. Okay, further discussion of that motion? Seeing none, Ms. Hanning,
Aye.
Mr. Platt,
Yes.
Mr. Cornick.
Aye.
Mr. Hinckley. Aye. It's unanimous. Please proceed. Thank you all for your patience with the wide-ranging discussion, but I think that will be a satisfactory resolution. Okay, now, I am on to subdivision resolution amendment, accessory dwelling units. May we receive a staff report, please? Yes. Oh, okay.
All right, so yeah. We made the changes to the standards, accessory dwelling standards, as we discussed at the last meeting. We tried to make those changes as best we could, so yeah. Yes, what do you think?
Questions to staff on the draft that was brought forward? Mr. Cornick, we'll just do a little round robin here to start.
No questions.
Mr. Platt?
I'm entirely satisfied with work.
Yeah.
I think a few questions, maybe just clarification. It seems unnecessary, it is, I guess, harmful, but to add one principal dwelling unit for 5 acres, and you've gone through and added the word principal to each of those. And yet, when we look at the requirements of lot sizes which is applied, they're precisely twice the density that applies to the dwelling zoning. So the statement, for example, residential dwelling density, 1 dwelling unit per 5 acres is still fully operative. Why do we need to add the word 1 primary? You still are not allowing more than 1 dwelling unit per 5 acres in a rural residential zone.
That is true. I mean, the original reason for that was because we were allowing more than what the density allowed. You know, I think it would be nice to have that in there, so if there was, in the future, we decided to change that, we've already got it defined. But, you know, when we wrote that, that was wise, because it was gonna be less than what the density allowed.
But I am understanding it correctly that that is entirely redundant. Is that correct? With the exception of ag.
With the exception of ag, correct, yes.
Okay, thank you. Then in the first paragraph, last sentence, additional or attached accessory dwelling may include la la la. And not considered multifamily dwellings. I don't understand the significance of multifamily in that statement.
So that is a use in the land use table, a multifamily dwelling, which means an apartment complex, or could be like a twin home or whatever, duplex. So we're differentiating between that and an accessory dwelling. So for instance, if somebody wanted to come in and do an accessory dwelling within their house or whatever, they're gonna use, I don't know, 600 square feet in their the garage to, I don't know how big the garage is, but 600 square foot. The rest of the house is like 1,200 square feet or whatever. That would be considered accessory. And we would allow that. But if they went to 50%, then it's not gonna meet their percentage, and it'd be considered a multifamily. And then other things would have to occur, like they would have to change the zoning to commercial. So it's basically, it's a different use defined differently than accessory dwelling. And that's why we note that in here, that it's not going to be considered. Basically, it's in here so they can get around having to change the zoning to commercial and whatever. We're looking at these differently than multifamily dwellings. Does that make sense?
A little bit. So multifamily dwellings are a use in other zones.
Correct.
It is a rural residential.
Correct.
And so this is saying that continues to be the case.
Yes.
Okay, thank you. That's the clarification. Just make sure I'm reading it the way you intended it. Similarly, there's a statement about provide an opportunity to develop small secondary dwelling on property for additional housing for a single household. What's the significance of for a single household? This is under section 8, paragraph A, first sentence.
Yeah. I'm guessing let's put there. What's that?
In addition to the existing language. So,
I'm not quite sure. I mean, not sure why we put that in there and why it's needed, I guess. I mean, we're trying to narrow in that there's a single. Maybe it's in there because that we don't want to allow a second dwelling that has multiple households in it. I don't know. Like, I don't know if that's needed. I don't know why. I can't think of why we put that in there. So, and whether it's needed either. So,
all right, I would move we strike it if it's a source of.
Is that anything that you saw, Matt? I mean, I don't know that.
I didn't have incredible opportunity to review this,
Okay.
but
I mean, we could just remove it, right? It wouldn't be problematic.
Well, if nobody knows where it came from.
Right.
Perhaps.
Well, I'm sure I put it in there, but I don't remember why, so. Unless it was something I was reading or something and somebody else had it like that, I don't know.
Like if we don't have a reason to add a restriction, we shouldn't. So,
Yeah.
Are you trying to guard against someone doing an accessory dwelling on a property that has a multifamily dwelling? Is that what it's meant to prevent?
I don't think so, because we don't really have multifamilies that we would, I mean, if they had a multifamily in their home or place, we probably wouldn't allow that, so
Right.
I think that could be struck. I mean,
Are there other issues with this, with the resolutions? If everyone's in agreement, can we have a motion to just strike those odd words that came in from somewhere?
I move that we strike the words for a single household.
For a second,
A second.
discussion of that motion. All in favor, say aye. Aye. Same sign opposed. Okay, done. Is there a sense of the commission on the overall resolution as amended? What would we like to do? There's certainly no rush on this one, but
Mr. Chairman, I move to recommend that we schedule a public hearing for this. To take place at our November 8th, 2023 meeting.
is that
I'll
a,
second
okay, that's second. Is that a sufficient motion to proceed, Mr. Gersh?
Yes.
Okay. Is there further discussion of that motion? All right, let us vote. Ms. Henning?
Aye.
Platt? Aye. Gordon?
Aye.
Hinckley, aye. It's unanimous. So that one goes on the docket, public hearing at our November meeting. Now, what about fencing? Subdivision resolution amendment on fencing. Who's presenting the staff report, Mr. Gerch, Mr. Ayers?
You can take it.
Can you do the staff report?
Yeah, so I think all was in my memo was Commissioner Ben David and Matt have worked on these fencing standards. I mean, you got to put in the required statutory amendment into our regulations, but we're going above and beyond, and they've drafted an amendment that would provide us standards for fencing that would protect wildlife, basically, so.
So is there staff recommendation here?
Yeah, whatever Matt wants to do with it. Yeah, we've looked at it too, me and Joe, and we're happy with it, so we would recommend approval.
Mr. Ayers, do you want to contribute something to that before we start questioning?
Sure, thank you, Mr. Chair, for the purposes of, systems laptop, for the purposes of, I guess like these regulations, Commissioner Ben David gave some proposals to me. I, worked with her to iron those out. Although I suppose that in full honesty, I have a few questions as to what exactly her thoughts were on why. If you read through that packet, there's sort of multiple fence types which can be used. 3 strand smooth wire fence. They have like their ideal, which is I suppose the first fence included in the proposed regulations that has smooth wire, 2 strands of barbed wire, and then either smooth wire of PVC or wooden post on top. So we're creating a 4-tier, or just the buck and rail. And there are a number of other sort of fence designs which are included in this Wyoming Wildlife Foundation sort of fence guidance. So I suppose I would have liked to have heard from Commissioner Ben David, maybe, what's wrong with like the three wire electric fence or some of these alternative designs, which were not included in the regulations.
All right, sounds to me like we have a ripeness issue here, but are there questions for these gentlemen? Anyone? Cornick?
So you're saying it might make sense to table this until she's here? Yeah, that makes sense to me. Yeah, there's a lot more in that brochure than there is in the regulations.
And it could very well be, I mean, I don't have a wildlife biology background, like Commissioner Ben David, so.
I don't have any.
Okay.
I agree with tabling it.
Okay, I had some questions, perhaps we could just explore it for a moment here. I'm certainly in agreement with tabling it. And maybe these would be guidance for as you look at this with some care, Mr. Ayers. Off the top of your head, how do these standards compare with the new state law? I think many of us were a bit surprised, perhaps taken aback with the specificity that was in that statute about barbed wire that has proven itself able to contain wild animals. So you have an initial thought on that, or have you had a chance to compare it to the explicit language in the state law?
Yeah, so I mean, that was my initial reaction when this bill came through and passed the legislature in the last session, was that, well, I mean, that statute had always existed and was always required of subdividers. This is just now the first time where the county actually has to require that information from them. You know, I think that and there's no case law on that exact standard of letting.
Well, the statute was passed just in this last legislature, right? At least this most recent one that talked about specific fence types and so forth.
So the requirement to have a lawful perimeter fence have been in effect for some time. Before, it just wasn't something that the county had to monitor as part of a subdivision permit. But it had been in place, I mean, since what, at least, it looks like 1997 thereabout.
But with that specificity of the wires and, okay.
Yeah, so all their fences may be constructed out of X material, which upon evidence is declared to be as strong and well calculated to protect enclosures, and is effective for resisting breaching stock, as those described in subsection A. So I think that, you know, we have this Landowners Guide to Fences and Wildlife from the Wyoming Wildlife Foundation, which has been out there for a decent amount of time. Yes, and it was designed. This guidance was given with the explicit recognition that these fences are going to meet that all other fences, which are as strong and well calculated to protect enclosures, and are effective at breaching and resisting stock. So.
Okay, so your initial thought is, yes, it would be compliant if we went forward with this.
Yeah, I think so long as we, keep it within this guidance, which was developed, between the Wyoming Wildlife Foundation and I assume coordination with the various livestock and ag interest groups.
And do we know what responsibility is for maintenance of these fences?
Well, so that is something.
And maybe these are all questions to be researched that we're not going to resolve.
Yeah, I did some. So I believe if it is a true perimeter fence, or if it's a partition fence, then that cost is split equally. That might not be the case. I have looked at this at some point out of curiosity. I can't give you a super definitive answer right now, but for the county's purposes, all we care is about that, at its very, well, not even at its inception, but just what is it going to be under a subdivision permit? down the road, that's between neighboring landowners.
Yeah, I just think it would be good for us to have a larger context and then we would come back to that and maybe Mr. David could contribute to that. I also questioned whether these more elaborate wildlife friendly fences are appropriate in all situations. The brochure had an awful lot of grants and cost shares in it. So I also had some concern as I looked at the first crack at this, that we ought to have some understanding of what it is we're requiring of folks by way of cost and so forth, and maybe it's different in different situations. Again, those aren't things we're gonna resolve tonight. Ought to be thought through.
And perhaps Mr. Gersh could speak to this, but just a perimeter fence for, your basic 3 barbed wire with metal post, that's not gonna be cheap, just to be, right out of the gate. And if that's, kind of the most basic perimeter fence required, it's gonna be costly for subdividers. But that was the legislator's determination.
Yeah, but the question before us is how much augmentation do we want to go beyond that at additional expense? And I guess I would like to have a little more information on that. Right, are there any other comments on that? And I'll open that to the public as well, if anyone wanted to weigh in on it. It sounds like we're in an exploratory phase.
That's right.
Mr. Gerich, Mr. Wells.
About the costs or?
I mean, just about the whole fencing amendment.
Oh, I don't like it at all, but we have to do it. So.
Well, we have to do it to a certain degree.
Yeah, no, anything we do that's different is gonna, put a burden on subdividers and, I don't know, there's some fear across the state that this is gonna shut off subdivision in the state in rural areas because they now have to, this additional cost is going to be significant for subdividers. I don't know if that's necessarily the case, but I know our counterparts in all the other counties fought against this. Not that it did exist in the statutes before, it's just now the county has to try to enforce it, which is going to be extremely difficult for us. I mean, honestly, we'll do a subdivision and we'll require them to say, oh, what kind of fence you gonna do? And they'll say, oh, we're gonna do this. Well, then when they don't do it, it's gonna be a mess. So.
That's improvement agreement is for.
Well, yeah.
So that's what kind of room is for?
Improvement.
Okay.
Yeah, the collateral.
Further discussion of this, it's
We'll work for Matt.
clear that we'll have to come back to this. Anything else you want to get on the radar? All right, unless someone hears something differently, I think we're looking for a motion to table this.
Mr. Chairman, I move that we table this item until our next meeting, October 16th meeting.
Is there a second?
October 16th, you mean our regular meeting?
Our regular meeting.
Is that October 16th?
I said October meeting.
Oh,
October 11th.
I thought you said.
October 11th, is it?
Okay, so I'll second that. You
All right,
table it
further
until-
discussion of that motion, and I think we'll assume that Mr. David will watch this discussion and we're looking forward to her participation and certainly extend to her our thanks for bird dogging this. And then I would add to that, at least in my case, a great deal of sympathy for the concept of wildlife friendly fence. Anyone who's ever seen a carcass hanging where an animal tries to jump, catches the second wire and twists, and that's the end of them. It's a sad sight to see.
So
So,
drive up and down 287.
yeah,
And look at the animals get trapped inside.
yeah. So it's a real issue. We need to grapple with it. All right, any other discussion of that motion? All in favor, say aye. Aye. Opposed, same sign. Okay, done. Let's take a short break and continue. That's acceptable. Thank you.
Welcome.
You bet. What's that?
Oh, yeah.
I was just gonna ask.
Click it off. I guess I can't do it.
What's up?
Are we on mute? No, it says we're okay.
Okay, I was just gonna ask if we knew what the public that had in mind.
Yes, I think they'll be pleased with your decision to go with the hybrid line. Their concern was they actually, I think you pointed out, I was like, look, this one just barely clips the corner. That was their property.
Okay.
So they actually own two 40-acre pieces. One of them, it just barely clipped the top of it, corner of it. The other one, it does go through it a little bit, but they weren't too worried about that because they have their house on the other one. And so, so yeah, that I think they'll be pleased with what happened.
That feedback, and they're of course welcome to bring their comments forward.
And while I'm up here, I apologize if I got a little too excited about things when we're talking about UPOZ stuff, so.
No,
I hate it. We're on this.
no problem. No, we appreciate
Yeah, so.
the diligence with which you do your
You better have passion than indifference.
Yeah. I mean, I was a little dramatic. I don't think people are gonna be out to get people, I mean,
They might.
well, they might, but not if you're gonna have to spend a bunch of money to do it, so.
Well,
I don't know.
right,
Just to concede a little bit there.
Well, Sue and I were just discussing some people.
I mean, we could chase legal, somebody could do this, they can sue you for any darn thing anytime, so at some point, you still have to draw the line. All right, which we will now do. Item number 5, discussion of building a 4th and Pine Centennial. That's it. Entertaining folks with the photos that you sent around. Of course, everybody swallowed Centennial Matters, was not surprised, so.
Yeah, so actually, Sue approached me last meeting and had me, or asked that I would put this on here.
For which we are not particularly grateful, Ms.
Adding any more to your agenda.
Yeah, but I'll just kind of give you a quick overview of what's going on. There's a gentleman by the name of Mr. Jim Hansen of Centennial. He has a building, or he has a property on 4th Street. And he came to the commissioners a few weeks ago, and in the public comment period, he just brought up how he was not going to be able to get power from Power and Light down the 4th Street right away because of the existing buildings that are partially in that right of way. And so he wanted something to be done. And so he brought that to the commissioners. I'll just give you a little bit of a background of just a brief analysis. For one thing, the buildings have been there for a long time, many years, decades. And Mr. Hansen just purchased that property not too long ago. So he knew that they were there. The building, or actually Centennial has a number of buildings currently in the right of way. So this is not the only instance where there's buildings in the right of way. So just to point that out, Albany County has changed our zoning certificate requirements within the Centennial plat to require a survey to ensure all the future buildings are built on their properties. So that was a recent change. I think you guys are probably in on it. Some of you were in on it, maybe. Yeah, so that was a positive change. So in theory, we should have no more buildings built, in the right of way. I know there's some assumptions there, like people do it before they, or come in and get a permit before they do it, and they follow what the surveyor says. But Albany County has no adopted regulations that pertain to buildings or structures that exist in the highway or right of way. Albany County does not maintain any of the roads within the Centennial plat. And typically these problems are referred to the individuals that go work with your neighbor and whatever that means. So usually means hiring attorneys, but so usually it's not a county issue, especially since we don't have any regulations to fall back on. But I mean, this is definitely a problem. And I guess Mr. Platt had asked me a couple of questions, and I've got the answers for those. So So Mr. Hanson, so his alternative is to go through, he can go through the alley that's below his property. That will add 132 feet to what he had to do in the first place. And so they have to, I guess the 132 feet is quite a ways, and it'll cost them additional $1,415 or $50. So 1,450. That was the estimate that I got from Carbon Power and Light. That's in addition to what it would cost the other way. So he didn't give me the costs the other way. So I'm guessing that's at least probably double. It's double or more. So I mean, it's a little bit of a cost. But there are alternatives for this gentleman to put the power in. But yeah, that's really all I got. I don't know if you wanted to add anything.
No.
Okay.
Questions? Go ahead. Well, long term, what will happen in Centennial with all these properties? And I took a look online, I was just amazed that are not on their property. I mean, how's that work? I don't know if you have any idea, Matt.
Yeah, well, one thing to note that like all of them that look like they're outside of the property lines may not necessarily be outside of the property lines. Because the mapping up there and because of the topography and trying to get the lines on top of the topography, it looks like a lot of them are not on their property, but many of them are. What has been happening, I guess, is folks have came into and they do a vacation of a road, and so they'll come in and vacate the road, and then it becomes, and then the county will then deed that property to those folks, and that has happened in a few instances. Because there was, I can't remember what the last one was, like somebody built their porch or something in the right of way, and so they were able to get a little piece of the right of way to be their property. Yeah, I mean, what the hope is somebody will really want to incorporate, and then it won't be the county's problems anymore. That's what we're hoping for. Oh, I'm just joking, but well, sort of. But yeah.
How were these easements created? I mean, originally.
Some guy sat down and drew triangles on a map and said, "Yep, this is Centennial." So.
No, Centennial was actually, it was platted as a town.
Around
By the, well, I think it was the mining company.
Okay.
Some guy out of Golden, Colorado. So, I think it was around before Laramie even. Because Centennial initially had the first newspaper in the county. So, there's that plat, which still serves as what those public right of ways are. Of course, it gets a little more tricky because it's not a county highway, it's a publicly dedicated, privately maintained roadway. And I suppose, Commissioner Platt, as to your question, regarding what happens, well, nothing. A private party can't adversely possess public property. So there's nothing that they can do that will divest the county of its interest as the fee simple determinable surface owner of those public right of ways.
Would someone occupying a portion of the public right of way be unable to improve their property further? Would they be limited in what they could do to a building?
So
They couldn't build in the right of way, no. This property that we're looking at, they came in for a zoning certificate. We said, no, you can't do that. You're in the right of way. And the remedy is if you came in to do a vacation and that was granted to them, then they might be able to do something like that. And that was told the property owner, but he never decided to do that.
So just to get us on the right page, it wasn't clear to me which of your pictures was the situation that we're describing. Was it the? Both, yeah. It's the same thing.
Which one is Mr. Hanson's?
So yeah, who's where?
Okay. Oh, okay. Yeah, sure. So let's look at the first one because it's the clearest. And I will note that more of that building structure is on the property than is shown on here. But there's still a lot in there. So if you see my blue square, it's touching those two long rectangle, whatever, properties to the south. Those are the property that's basically in the right of way. That's the property he owns, then the buildings are partly in there. The big square to the east. Is that right? East, okay. Sometimes I get mixed up, but that is the gentleman, Mr. Hanson, that
He owns both of those.
Yes.
So this
okay,
property
owns
owns
both
both
those to the east.
but the houses, the buildings are here.
Right, okay.
There's a lot of names like.
Yeah.
My neighbor was the same way.
Okay. So other questions of Mr. Gersh, Mr. Ayers?
Were you going to discuss the matter of short-term rentals?
Well, we'll get to that
Okay.
next time. So for these guys, my understanding is that there's no jurisdiction here. There's nothing that this body can do with Mr. Hanson. Is that basically this conclusion? I would point out that it is a screaming example of why we have planning.
Yeah, right.
When we do have planning. So it was a little admonition for the future, but yeah, Centennial.
It also speaks to the importance of survey.
Settle for a good
Like
GIS.
Well, and that's been an issue in this area too. Like you have one surveyor come up and, oh, this is where the lines are. Another one comes up and yeah.
I was introduced to a map by one of the surveyors of the promise that I wouldn't take pictures or make any notes that showed all of these overlapping properties. So I sold this to you and then somebody else sold that piece of it to somebody else. No, it's a colossal mess. So where do we live, Mr. Hanson? You just told him you would bring it forward for our commiseration or what?
We haven't actually responded to him yet, so I corresponded with the attorney's office and we're coming up with a response, so.
All right, but the basic response will be, we have no jurisdiction. Although the situation you alluded to a moment ago is, as I recall, the county was paid for the vacation of a right of way. Is that, am I remembering that correctly?
I don't remember that, so. Yeah, they have to pay for the vacation, or there's like a little bit of a fee, right, for the vacation. I think they do like a $200 fee or something, and then I think that covers the cost of notice and some of those other things. That's what the clerk was doing. I don't know, maybe
I think
I'm wrong, but. Because I think the statutes allow for,
yeah, I worked on this as an intern like almost 4 years ago.
Yeah.
Yeah, but yeah, I think that the resolution was that the county isn't going to ask for like actual payment of that kind of
yeah,
vacation, but I think recouping the fees is a different story.
Okay, I guess I had remembered it somewhat differently, that this woman had come forward asking for a vacation of easement, and the county at the board level had said, you are asking us to give you something of value, and the answer is no, it's not a freebie, it's not a gift. Then perhaps Commissioner Ibarra could enlighten this. This has all been in the last couple of years.
Yeah, this wasn't Gustafson.
I don't recall the name, I just recall the discussion being, the
Yeah.
neighbor offered to bulldoze the house.
Yeah.
There was
Yeah.
one case that kicked all of these off.
Right.
All right, well, maybe that's immaterial, this is a specific problem.
I think the city.
Never was the commission asked for a payment.
Okay.
We had asked for a payment. I think we might have looked at it as land value and why would we give up
I would think that the county
that
would.
belonged to the county,
The
just
county would ask
flat
for
out.
remuneration for giving up something of value, that would seem appropriate, but anyway, that's getting tangential to the discussion here.
that's a legal thing too.
All right, anything else
My
there?
apologies, Mr. Chairman, I was combining these two items together under Centennial. I forgot they were separate items.
Okay. So anything else on our Fourth and Pine? Hearing none, let's move on to the next item. We're going to discuss short-term rentals in Centennial, a very large issue. There was a big story on NPR here in the last couple of days on how other large communities like New York are bedeviled by these issues. All right, go ahead.
Yeah, so Mr. Chair, I'm bringing this forward because I've been contacted by a group, well, an individual, I should say. I assume there's a group behind the individual, but I know there are other folks that are interested in it. And they've brought a whole lot of things to our office about short-term rentals. They feel like they're really kind of hurting Centennial. And so basically, I just wanted to bring it to you guys to discuss. We've brought this to the Planning Commission at least one other time, maybe twice, to discuss. They're kind of an oddball thing, because when people look at these things, they're like, well, they're not being taxed like, a hotel or whatever, and they don't have, what's that? Lodging tax, or they're not being not being treated like a hotel. People aren't in there. There's not health inspectors and these types of things, and they bring up a lot of these issues, and all those issues are not our jurisdiction. We don't deal with those. We don't care. But I have done a little bit of research. It's interesting because the state taxes them as a lodging entity, and they probably tax like Airbnb or Vrbo or whatever company it is that are doing these or whatever. I'm guessing that's how that works. But the county sees them, the treasurer sees them as just a single family home, and that's how they're taxed, or apartment or whatever, and that's how they're taxed. So there's no differentiation at the county level, but the state does get their taxes. The hard part about regulating these things would be enforcing them. I've had discussions with other planners, and I know a lot of jurisdictions, or I know of jurisdictions that do not regulate them because of the cost to enforce them outweighs the benefit, basically. Because they're extremely hard to enforce. Just because you see an advertisement on one of those sites does not necessarily mean that you can say, well, they're doing that and that's legally good enough. From what I've heard, I don't know if Matt's done any research on it, but I've read some things, and I don't know. I guess I'm just bringing to you guys to discuss. The folks from Centennial, I don't know if you've read some of their materials, but there's a lot of assertions there without a lot of data to back them up. Just for my overview, what I looked at. So yeah, I don't know. We're limited on what we can do. I don't necessarily think, can we require licensing? I don't think we can in the county. The only thing we could do is use our zoning code. And so what we could do is, if we were going to regulate them, it would be a conditional use permit, which that would effectively stop any more from happening, I would imagine, because people wouldn't, I'm guessing all the neighbors would come out, especially in the Centennial area, to oppose them, and nobody wanted to do that, and it wouldn't really fix, if there is a problem now, they already exist and they'd be grandfathered. So the ones that came after that we could stop, but the ones that exist now, and if they came in and said, hey, we're already doing this, then they're a non-conforming use. So there's bunches of things to talk about. So we may hear from these folks. I know they just put out a petition or whatever, so
they'd be grandfathered even though they should have had a conditional use permit from the beginning, maybe?
They're not required to right now. That's the problem. It's like we view short-term rentals as a monthly rental, or as a person that owns it is in the building. We view it as a single family home. We view it as a dwelling that somebody's living there. And we don't differentiate between how long they're living there. So,
So all that they wrote in there about how they are in violation isn't really true because of the way the county's been.
the way we interpret the regulations, they're trying to say that short-term rentals are the same as a hotel. They are not the same as a hotel. I mean, any reasonable person could say that house is not a hotel, you know?
They are a business though.
That could be true, yes, but also they're trying to say that they're similar to a bed and breakfast. I thought it was interesting because one of the definitions that they provided for a hotel, they left off half of the definition. You can look it up. It's the first definition they give, and it's off of like dictionary.com or one of those or whatever, but they left off the part of restaurants and other things that would be in this and all these accommodations that are part of a hotel. And I don't know. So I do not agree with that statement. If their assertion that that we're not following our rules is incorrect, in my opinion. So
Following up on that, I think I'll have the same question. And the most telling of the accusations was that they are a commercial activity, not in a commercial zone. So
But so is renting a house.
what is,
you
what
can
does it take under our zoning to be commercial versus residential?
Comes down to the land uses and how you have those defined.
right. So a dwelling is allowed in all residential zones, and that's what we consider them as a dwelling. That's the use.
And where does it become commercial? I guess that's right. If I'm renting out my dwelling with a big sign on the street.
So I guess conceptually, the commercial zoning resolution doesn't say that only commercial activities can occur here or that commercial activities cannot occur in residential zone. It really just comes down to the land use table. That's what ultimately controls. And there's nothing in the land use table which at all addresses short-term rentals, VRBOs, those sorts of things.
Or long-term rentals.
Or long-term rentals for that matter. Well, and you're gonna run into some massive constitutional issues there for long-term rentals.
Right.
But yeah, how Teton County does it is they just, in the equivalent of their land use table, they say boarding houses, and they include short-term rentals under the land use of boarding house, I believe. I looked that up many months ago. So that's how you would address it, is you say, this is the land use for short-term rentals, and these are the zones that you're allowed in. Because, it really just depends on what the use is within the land use table, not what its overarching, I guess, designation might be.
But the land use table would classify a motel as commercial.
Yeah.
And so then somebody draws the line between a motel and a short-term rental.
Yeah, I think pretty reasonably so.
I don't feel quite as strongly as Mr. Hirsch expressed it. If I see a house sitting there with a big, you can stay here for $200 a night.
They had a sign and it was.
That looks like a motel.
Sure. I mean, I guess.
But there's no, free HBO mini fridge.
Well, do they have color TV?
But do they have 10 people? And you got in a house that was, the septic system was signed, size for.
And that's another issue.
There could be some real impact.
See, and that would be
Apart from the
more,
social impact.
that is probably more problematic than most of the other impacts. I mean, if you look at a short-term rental and what are the impacts of the short-term rental compared to a monthly rental, compared to an owner living in the house permanently. I mean, other than maybe there's more people in there impacting a septic system. I don't know, maybe there's some other things that I haven't thought through, but that's what we're trying to regulate, is like, how are they impacting everybody around them? And I mean, some of the excuses I've been given, I actually received a letter from an attorney that said that they have seen people with out-of-state plates in their neighborhood. So, and just a fun fact that I found out today, I did a little GIS query and I just in kind of the Centennial area that I found 600 parcels. And 200 of them were owned by, or where their tax assessment stuff was going out of state. So that's 1/3 of the houses in that area.
That's not even
For
including the
properties.
people that don't live in, like that are from other places in the state.
Right, and that, yeah, so they might not have been from Laramie or Cheyenne, they could have been from somewhere else in the state that, I didn't look at the Wyoming stuff, but I don't know, I mean. Yeah, and really, this is the only area this is really an issue, if it is an issue, is the Centennial area. So if we were to do something, we could, I mean, options we could do is we could do an overlay zone for that area. And then have specific standards for a conditional use or whatever. That would be kind of what, if you wanted to go that route. I'm not totally against regulating them. I think they serve a purpose too. I think they bring in a lot of people and a lot of money to the state and to our community. So I guess I don't see them as bad a thing as others do, but.
Thanks, Mr. Chair. So going along the lines of an overlay zone and theoretically constructing regulations that put it more on that a neighbor who's upset has a way to call a property management company and complain about what's going on. I mean, that you leave it as a do loop amongst the people who are renting and renters. Would it apply if people said I was already doing this and I'm grandfathered in? I mean, can you retroactively come in and, so what about, I'm just thinking of all the, maybe it's because there's cities and not counties, all these cities who have dealt with this issue have, I think, are coming in retroactively, maybe they can't either. But,
In some states, you can do like amortization periods. That might not be the right word. But where, so there are certain state statutes, like I remember a case from law school, like Vermont, where, cities can say within, 10 years, all non-conforming uses have to cease. Wyoming legislature has adopted that.
So given the difference between city powers and authorities and county power and authorities, if Centennial really wanted to solve this problem, they should incorporate as a city, and then they could come out with rules that would apply on the spot to the situation, right?
Ordinances, yeah.
And so if Centennial really wanted to solve this problem, they should incorporate and take control of the situation.
Absolutely, I think that's a good recommendation.
Sounds like there's an organized group. Maybe you could put the energy into whatever it takes to incorporate.
Maybe I'll help them out with that, I don't know. We should, anyways.
More questions? Well, the first question I was gonna ask David, you already addressed. I was gonna ask you if you basically accepted this document as being substantially correct. And you have said a lot of these things are unsupported assertions or.
I mean, I think there's good points in there.
Yeah.
I mean, like,
but it wasn't,
yeah,
they were making their side argument, which of course they would.
right. I just think there needs to be more data if they're really gonna make the assertions that they've lost 5 businesses. And it's like specifically correlating to short-term rentals. Just because a business owner sells their business and they use it for something different does not mean that was because of short-term rentals. I don't see that, but.
Well, I would just say to everyone here, that aside from the regulatory issue, whether or not taxes are being properly paid in the state or wherever, the description to me does sound like a small community crisis. I mean, a lack of affordable housing stock. And I don't know that we have any ability to do something about that, but it does sound like a serious problem. You'd hate to see all the people who work at Sawyer Range here have to live in Laramie and mid commute versus if they used to be able to live in Centennial and now priced out and so on and so forth. it's not like Jackson Hole, but it's like a very small, much less expensive version of Jackson.
I guess, and, I mean, if it's unmitigated, if they're correct, then eventually the town just kind of collapses, right? Because the Airbnbers aren't gonna wanna be there if there's no store or restaurant.
So in some, I have some sympathy for that.
Sure, and that's, I would say that's one of their valid points, is like, it does affect housing. It does, for sure.
And we had that person, oh, sorry.
Oh, good.
Remember that person who came and spoke to us from Rainbow Valley last summer or sometime? About, having to constantly dig out people who are unprepared, and that's a real impact. And you're not gonna leave them stuck in the snow, you can't do that, but you shouldn't have to be digging out somebody else's customers all the time either, right? I mean,
Right, yeah.
it's a real thing, yeah.
I guess doing the overlay zone would at least stop additional, you could stop additional units from going into short-term rental mode and taking it out of the housing stock. And having some kind of like the rescue thing, I mean, it's that there should be some accountability by the person doing the renting to have a system in place where a property management company can be called to say, hey, so-and-so stuck in the snow, or we're complaining because these people are blaring music until 2 a.m. And I don't know, I think a lot of communities have come up with reasonable ways of having the aggrieved neighbor have a mechanism to complain and get action without it having to come to county staff. But I don't know.
Yeah, in like cities, you brought up cities have the licensing authority and they can put a lot of stipulations on how they're doing it. But one of the things I was thinking with the overlay zone, it's, it could be more than just for allowing conditional uses. Within an overlay zone, you could limit, put distance limits. You can only have one, Airbnb or short-term rental every 1,000 feet or something, or, I mean, you could space them out. And so you wouldn't necessarily have to say you can't have any more, but you could do spacing, you could do some of those things. Yeah, so really I'm just trying to get ideas from you guys. If you want to look at some of this stuff, we would be happy to bring some forward at some point. But I mean, after we get all these other things done.
Just one question. Who's the author of the extensive report that we have? I'm resistant to things showing up anonymously.
I don't know, but I can tell you the lady's name is Allison that has been corresponding with me. And I don't know her last name off the top of my head.
Does anyone show up at your office?
No, email.
Well, just as a general notion.
We've had some good discussions over email.
If someone wants access to our packet, I would like to see us insist that it be authored, so it doesn't just appear.
Oh, okay.
Just as a general practice, I think that would be good. As far as the general topics, I don't know that I'm completely convinced that we can't address this within the existing land use tables. Like I said, I need to go back and look at that pretty carefully. I'm maybe not, it's not quite as obvious to me that there's a hotel and an Airbnb, and the fact that they are escaping lodging taxes and some of the things that helps our community fund its activities. So
I believe we need to make an entry for short-term rentals and add a further regulation.
well, if they can't be interpreted to already be there, I guess that's what I'm a little skeptical. If I go back and look at that. All right, but I guess the question that's being brought to us by staff is, do we want them to look at this further? It sounds to me like there's interest in doing that, under just the general notion people in Centennial are county residents and at one point, maybe before I was on the commission, somebody came forward. This is a recurring problem out there, and I had very little sympathy for him. It was, well, we're seeing strangers in the neighborhood. Well, we do not regulate the strangers. People driving down your street, we're not proposing to. But we do regulate land use for quality of life. And that's why we have densities and so forth. And I think this bears on that. So it's appropriate within our larger embrace. So I guess, speaking for myself, but certainly let's hear the rest of us, I would like to see staff look at some possibilities for how to address this.
Well, I'm interested also. I mean, this is not gonna be like Jackson, but still, this is kind of analogous. And I think it's just unfortunate, whatever happens, that people get priced out of going within the community they work in.
And that's the kind of thing planning and zoning can
You would think.
mitigate. You would hope.
You would hope.
Correct, what's your thoughts on how?
Yeah, no, I agree, and I think that community is valuable, and this sort of thing tears down community. Centennial's always been kind of a cool community. I can see why that causes, this kind of thing causes the stress there. You know, it's because people that come in to stay in an Airbnb, they're often, well, the stereotype is that they're often inconsiderate and not good neighbors. I don't know how true that is, but it sounds like it is, at least sometimes.
It's true
I'd like to
with
see-
long-term rentals too,
Oh,
sometimes.
is it? Yeah.
So,
Well, I was also like, yeah, I'd like to see.
or
it.
permanent residents, so it's like, I don't know.
Yeah,
Did you want
I like-
to,
Yeah, I'm in agreement.
do you want, is that sufficient direction for?
Yeah, I mean, what we'll probably do is we'll just do some basic research and bring some options. I think this would be a good idea, because I'm guessing these folks, they're doing a petition, so I'm assuming they're gonna give that to somebody at some point, so if we maybe have something that we're working on that can show that we're hearing. But one thing that I would caution us is, we're hearing one side of the story. We're not hearing everybody in Centennial. I've heard anecdotally from another person that they view it totally different, but they own one of the short-term rentals. Yeah, so I guess let's not jump to do something too rash without making sure we hear from both sides of it. Because I'm getting is, or mostly I'm getting from this one individual, and it's like, is this how it is across Centennial, or is it just, a few people, or, you never know when you're just getting an email from one person and they're saying this is what the whole community is saying. I just don't know what that really looks like.
But I think we do know this is a national problem. This isn't just Centennial, and these same
Right.
issues emerge elsewhere. So, yeah, there are gonna be two sides to it.
There's 23 of them, which I don't know if that's a ginormous problem in Centennial, or there's hundreds of houses, but I guess I don't know.
All right, well, let's see.
Yeah.
But it sounds like the consensus is this is worth looking at in the spirit of appropriate planning and zoning for the quality of life in Albany County.
Well, and look into the future, because there's 23 now, who knows what it'll be next year, so, yeah.
Okay, thank you. Next item on our agenda is open-ended executive session. Mr. Ayers direct us to go into executive session. We have to offer some modicum of reasons.
Yeah, so originally, I believe from the last meeting, I had stated that if you wanted to hear more about, I suppose, the legal authority of aquifer regulation, that would be a matter best discussed in executive session, so I'm not sure if that's still relevant.
And under
At this
the
point.
criteria for executive session, that qualifies as what?
Confident, or
That's what I'm looking for.
I would have to get a site for you.
Executive session is abused in many organizations. I'd like to keep us on the straight and narrow.
It is, but confidential legal advice is not abuse of that.
Is that what we're doing here?
That's what it would be, should you want it. I think I said, if you want it, and David put it on the agenda, so I don't know if this commission wants it.
I'm sure we're gonna need a motion to go into executive session for purposes of receiving confidential legal advice. Would that be the correct?
It's best to cite to the exact. I'm sorry, let me try to find that.
Okay, I mean, because I'm interested in the discussion, yes.
Sure, so I put that again.
Okay, let's just do it right.
Well, it could be, yeah, I'd say. Be pursuant to 16.4.405A. III and IX.
Since I brought it up, I'll just make a motion that we move into executive session for purposes of receiving confidential legal advice under the provisions of Wyoming statute
405.
405A, Romanet 3 and Romanet 9.
I'll second that.
We have to vote first. We're still in open session. Discussion of that motion. All in favor, say aye. Aye. Opposed, same sign. Okay, we're moving into executive session and you can appropriately press your buttons. Hit the appropriate button. Thank you to all of our loyal listeners for their patience. And we're on to other items on the agenda. Next meeting is October 11 at 5 o'clock in this room. I will not be here in person, maybe it will be by Zoom. Mr. Platt, it'll be on you to be the referee at that meeting.
I'll do my best.
Commissioner comments, I've heard a lot of them. Anybody got anything they want to get off their chest?
I will also try to come on Zoom, but I'll be out of town.
Okay. Let's keep David posted to make sure we have quorum.
Right.
Or we'll be
I will be here.
Okay, and I don't know what Muraugh's situation is. In fact, David, you might make a quick tour of the commissioners, say, I don't know, 2 weeks out or something,
Okay.
and see who's gonna be there.
Do we have anything?
Okay, we have,
permits.
what's that?
We don't think we won't have any permits on that meeting, so
Okay,
if there's a reason to not.
yeah, I mean, if the agenda is small, we move some of this to a special session. All right, well, let's get our heads together on that before that comes up, but keep your calendars clear. We warned the citizenry out on our citizen comments.
Yeah.
No, and we welcome their participation and the patience that is required sometimes, but certainly no one should take from our meetings anything other than a welcoming attitude to public participation, regardless of whether we're in a specific public comment period or not. All right, hearing no further business nor objections, I will declare this meeting adjourned.